Good morning, Mr. Procedural. Good morning, everybody.
Morning, Chair.
Yes.
You've set down for final hearing the application for cross-examination of Minister Gordhan on behalf of Mr. Moyane, and I believe Mr. Mpofu will commence.
Yes, just for the record, we are interrupting the evidence of Colonel Naidu for me to hear an argument on an application that has got nothing to do with him, relating to leave to cross-examine sought by Mr. Moyane, that is leave to cross-examine Minister Gordhan. And we will resume the hearing of Colonel Naidu's evidence after that. Yes, okay. Well, maybe we can just have everybody place themselves on record first, and then Mr. Mpofu can start.
Thank you. Good morning, Chairperson.
Good morning, Mr. Mpofu.
Thank you. Chairperson, I appear once again for Mr. Moyane in this application with my learned friend and junior, Mr. Kasiboto.
Yes, thank you.
Morning, Chair. I appear for Minister Gordhan in this application and place on record my gratitude for the timing of the application this morning. Thank you.
Thank you very much. Thank you.
Chair, can I have permission to have Mr. Kasiboto sitting here?
Yes, it's fine, yeah.
I don't want him to be evicted by Ms. Norman.
No, that's fine.
Thank you.
Well, I'm just going to summarize, to make a few remarks that are intended to facilitate argument and expedite it. And as you address me, I will sometimes be making remarks or putting questions that might not all be intended for you really, but that might be intended to assist Ms. Leroux to know what's in my mind, so that when she stands up, when she rises, she can address all of those issues. As you recall, except in regard to one issue, I dismissed Mr. Moyane's application for leave to cross-examine Minister Gordhan, and I gave reasons for that. And I subsequently asked both sides to file affidavits or make written submissions, which was done. And one of the things I wanted was for Mr. Gordhan to clarify a certain issue in his affidavit. I think from his clarificatory affidavit, he understands that he thinks I misunderstood his affidavit. Maybe I did, but if I did, I think then it must be because there are various parts that might that give one different understanding. That issue was really whether Minister Gordhan was saying that in laying criminal charges against him, Mr. Moyane acted with malice. And of course, acting with malice could be based on various things. Could be because you just don't like the person. It could be because you have a certain illegitimate agenda you want to put the person in trouble. Could be all kinds of things. But his clarificatory affidavit, well said one, it was never, he never said in his affidavit that Mr. Moyane acted with malice. He said it was Mr. Moyane's who said in his affidavit he understood that it was implied in Mr. Godin's affidavit that he had acted with malice. And, but in the end, well, at some stage, Mr. Godin says in his affidavit, clarificatory affidavit, that he didn't know what was in Mr. Moyane's mind when he laid charges against him.
Yes.
And somewhere he says whatever may have been in his mind was irrelevant. Maybe if he had stopped there, there might have been no need for this hearing, because maybe that would have been a ground for me to say, well, he's not alleging any malice against Mr. Moyane in laying charges, therefore there is no issue.
Yes.
But in his affidavit, he then
Goes further.
went further and said, as I understand his affidavit, what he did mean, or what he does mean, or what he does contend, is that Mr. Moyane abused the legal process, by which I mean, I understand him to mean, in laying charges against him, Mr. Moyane abused the legal process. And he then also says, as I understand it, his affidavit, he says, in effect, Mr. Moyane was doing this in furtherance of the state capture agenda. I may be putting this in my own words, but that's how I understand it. It may be that he is not confining this to the laying of charges. Maybe that he goes further to say there are lots of other things that he did while Mr. Moyane did while Mr. Godin was Minister of Finance, which Mr. Moyane did as part of furthering the agenda of state capture. Now, my prima facie view is that within the context of this commission, if you say that somebody did certain things to further the agenda of state capture, that's quite a serious allegation, and that provided all other requirements that need to be met for purposes of granting leave to cross-examine, provided they are met, the inclination would be to grant leave to cross-examine, because it's quite a serious allegation. But of course, Minister Godin says, the basis for me saying that Mr. Moyane was acting as he did in furtherance of the agenda of state capture is now to be found in the findings of the Nugent Commission. So then the question for me arises, okay, how do we deal with this? And then, of course, Mr. Moyane did not give evidence in the Nugent Commission. So there's the question of his version. Hence the idea that maybe if I end up being inclined to grant leave, there would need to be some provision for Mr. Moyane to provide his version in relation to those findings. Basically, that's my thinking, and most of it would have been in the letter in the email that was sent to you. but then you can address me. You have a full picture of what's in my mind.
Yes. Thank you, Chairperson, and also thank you for giving us a preview, so to speak, of your prima facie view. It might or might not, depending on the attitude of Ms. Leroux or Mr. Godan, curtail the proceedings. Well, Chairperson, then really we have two issues that I need to deal with, broad issues. There might be sub-issues within them. The first one, which I want to deal with very quickly, is to confirm that your prima facie view is correct. If I persuade you that that prima facie view is correct, or if Ms. Leroux doesn't say anything to disturb that prima facie view, then I will address you, Chair, on what should then happen. The options, there were two options which you presented.
Yes.
Option one was that you would grant leave, or rather, you would ask for a version and then give a ruling.
Yes.
Option two was that you would grant leave provisionally, so to speak.
Yes.
Grant leave provisionally on receiving a version. In our response last night to you, we presented a third option, which is what I want to address in my second leg. That third option is that the chair should actually grant leave unconditionally. And I will address the chair as to why. And that is because our view is that the linkage, which your chair has just articulated, between the allegations of malice, if they stand, and the Nugent report is in our view, unsubstantiated, and it cannot stand. And I will address Chair on that. So let's start quickly with the first issue. Chair, you will recall that in our submissions, which we filed on the 28th of May, 2019,
yes,
we made the point that the Chair is making, namely that one cannot say that the allegations were not made without malice. It's inconsistent with the very affidavit of Mr. Godan. That is why we didn't even file an affidavit, because our view was that it would be a waste of the time of the Commission, because in his own affidavit, there's enough to sustain the accusation. And we quoted at page 2 of that document some of the excerpts that the Chair was referring to. We say he has never denied the imputation of malice. And I'll explain why we say that. All he does is what we lawyers call confession and avoidance. In other words, he says, yes, you are malicious, but it's irrelevant. Yeah. Now, I'll show you to you, Chair, that it cannot be irrelevant. And once you remove the avoidance, so to speak, then you are left with the confession, which is that it was malicious. And therefore, on that basis, the leave to cross-examine should be granted. And we then list the 4 quotations from his affidavit. It's a 7.1 of our submissions, rather paragraph 7. He says at paragraph 15 of his affidavit, I'm quoting the affidavit of Mr. Godan, the key point of my evidence was my personal belief that the entire process of investigation and bringing, which is what Mr. Moyane did, and withdrawal of charges against me by the NPA was part of a campaign of state capture institutions. He then says at paragraph 22.4, I therefore do mean that Mr. Moyane was motivated wholly or in part, or he sought to advance the objectives of state capture. And he was abusing a legal process for his own personal goals. Then the third one, he says, I believe, that is now at paragraph 22.5, I believe that Mr. Moyane's personal goals included the advancement of state capture. And then he says at paragraph 31, my personal belief remains that Mr. Moyane abused his position. Somewhere in his affidavit, he even says Mr. Moyane was motivated by racism. Now, the simple point we make there, Chairperson, is that it hardly lies in the mouth of a person who says these things to deny that there's an imputation of malice. Because how can you abuse, lay false charges, so to speak, in the advancement of the state capture project, but you do it nicely, without any malice, without any malicious intent? It's just nonsensical.
Yeah, you see, as I understand his affidavit, certain parts of it make you understand it differently. I mean, in the direction that I issued when I asked for a clarificatory affidavit, even in that direction, I did say that when you read certain parts of his affidavits, you think he is meaning this. When you read other parts, you think he's on this issue of malice. I did say that.
Yes, you did, Chair. Yes. Even in your ruling, by the way, you said, well, we differ with that, because you said in the ruling, if I remember the words, that he was equivocating.
Yes.
Now, our view, of course, is that he was not equivocating. He's very clear.
Yes, Well, it's an interesting situation. I thought he was equivocating. You thought he is very clear.
That it's malicious.
He agrees with you. He thinks he was very clear.
Yes.
But you are on opposite ends about that clarity.
Yes, of course.
So, naturally. Anyway, but when it comes to malice, I think that if you try and understand what he has to say about malice, insofar as you take the issue of state capture agenda out of it, I'm far from certain as to what he says.
Yes.
Yeah, but once you bring in the aspect of state capture, it seems to me that it would be difficult to say. It would be difficult to say somebody was laying charges against you in pursuit of the agenda of state capture, but he was not acting with malice. But maybe it can be argued, I'm not sure, but maybe it can be argued. That's fine. So he may be making some distinction, but it seems to me that even if one were to say, let's leave out the issue of malice, the moment you say what you actually mean is that this person was acting in pursuit of the agenda of state capture.
Yes. That's enough.
That is the kind of allegation that should ordinarily attract the grant of leave to cross-examine if all the requirements are met. Yeah.
Thank you, Chair. I won't even spoil that. That is exactly what we're saying. In other words, the alternative and shortcut, so to speak, is to say, let's forget about this debate about malice and the semantic meaning of malice. Let's just look at what he says. Forget malice. I, therefore, do mean that Mr. Moyane was motivated, wholly or in part, or he sought to advance the objectives of state capture in laying the charges. It can't be clearer than that. So that addresses a double-barrel answer to the whole issue, because it both addresses the question of motive, but it also addresses the question of relevance. Because if he was doing this to advance some other motive about football,
personal things,
then it had nothing to do with you, Chair. But if he's doing it, the malice, the kind of malice is in advancement of state capture, then it's in your zone. This, after all, is the State Capture Commission. So any accusation that is motivated by state capture must be. Well, A is clearly negative to Mr. Moyane's interest, so that he wants to cross-examine on it, but secondly, it's relevant to this commission. So I won't address that any further, Chair. As I say, the affidavit speaks for itself. It doesn't even de-link the so-called malice and motive from the laying of the charges, which is the core accusation. It says that action of bringing was part of a campaign of state capture.
The part of the concern I have, and this is one of the things I'm mentioning so that also Ms. Leroux can think about it. One of the concerns I have is that is whether insofar as the clarificatory affidavit of Minister Godan says, whatever Mr. Moyane did, he did in pursuit of the agenda of state capture to get me removed as Minister of Finance so that another minister who would go along with that agenda would be put in. Another concern I have is whether that doesn't have, if I allow cross-examination on it, doesn't have the effect of opening up effectively the whole issue and all the issues that I have already decided there should be no cross-examination on. So if I were to grant leave, part of my concern is how do I make sure that this doesn't unravel, as it were, what I've already decided is not going to be the subject of cross-examination. And of course, you will recall that in the direction that I issued in directing that there should be a clarificatory affidavit, one of the things I said was that this should not be used to bring up new issues. I think that I said that. Now, of course, the moment I think about whether Mr. Godan is bringing up new issues when he says Mr. Moyane did this in furtherance of the agenda of state capture, the moment I'm thinking along those lines, I then remember that what he says in his clarificatory affidavit is what I meant in what I was saying in my affidavit, or what I mean is this. It seems to me to be clarifying what he was saying in the previous affidavit. So there is that issue. So it would be important, as far as possible, it seems to me, subject to argument, that whatever happens, if I do grant leave, I should put in checks and balances that would make sure that whatever I've decided is not going to be the subject of cross-examination, should not be undermined. So that's what's in my mind, and you might be able to.
Yes, no. I won't spend much time on that because we'll probably cross that bridge.
Yes.
If and when we come to it.
Yeah.
But suffice to say the following: this issue arose in the context of what we called Theme 5. If you remember, we had 5 themes.
Yes, yes.
In respect of the 4 themes, the chair refused cross-examination. And by the way, we have instructions to take that decision on review.
Yes.
But that's a matter for another day.
Yes.
As far as Theme 5 is concerned, and the issue that the chair narrowly defined, Chair, you're quite correct. There is bound to be some spillover. That spillover, however, can be contained. And the spillover comes, for example, in the following fashion. You remember when you opened, Chair, you said that Mr. Godan says that his attitude was informed by the Nugent Commission. Yes. Now, that issue is clearly integrally related to this question. And number one. Number two, you'll also remember that our argument was always that, remember there are 2 things here. At the end, the chair must either accept Mr. Godan's version, that Mr. Moyane is a state capturer, conspirator.
Yes.
Or the chair must accept that, no, Mr. Godan acted as any commissioner of Sars would have acted in those circumstances. There's no halfway house. Now, for that to happen, then obviously Mr. Moyane is going to have to take the chair into his confidence, even in terms of the questions that he puts, as to why he says that his version is correct. Mr. Godan, on the other hand, in answering the questions, will say, no, all that notwithstanding, you were part of the conspiracy or whatever. So it's inevitable that questions such as whether the reliance on the Nugent Commission was correct will have to be answered. What even compounds it further is that since we last spoke here, there have been two significant developments in regard to the so-called rogue unit issue, which was at the core of the charges. And that not that it's good or bad or indifferent. There is such a thing. The second is that the Inspector General's report, which was part of what Mr. Moyane relied on, has been, and I'm using the word loosely, borrowing from the media, declassified. I don't think it goes that far, but let's just say at least it's in the public domain. Now, it's not possible for Mr. Moyane, Chair, to convince you or Mr. Godan or anybody that he was acting bona fide without saying, I relied on the Sikakane report, I relied on the KPMG report, I relied on the Kroon report, I relied on the IGI, the IGI report. And by the way, the so-called Nugent report, final Nugent report that is now being used opportunistically, did not even exist. Mr. Moyane's charges were in 2015. Mr. Godan's evidence here was in November 2018. And Mr. Nugent's final report was in December 2018. So when he was sitting here, he could not have been motivated by anything that Mr. Nugent said. And that is why, Chair, I'm almost getting into my second argument. That's why we say it's a red herring, this whole thing of the Nugent Commission. And the Chair should give the leave to cross-examine without any regard to whatever is in the Nugent Commission. And we have, I'll outline 4 reasons why that is so, Chair. One is that we say actually, this suggestion is motivated by what we call perjury on the part of Mr. Godan. Because Mr. Godan, the Chair was correct in his summary of the, in the ruling, that Mr. Godan actually says that at page 399 in his affidavit, more important, for the purpose of this application, the Nugent Commission specifically found that the so-called rogue unit was lawfully established and recommended that it sought to be re-established. Then later it says, it is instructive to consider how emphatic the Nugent Commission was about the legality and of the establishment of the so-called rogue unit. Now, Chair, I will not bore you with reading it out, but I will refer you to what Justice Nugent says in the interim report, which did exist, at page 245 to 6 of these papers. And I'll also refer you to what he says in the ruling on his recusal, or rather the recusal of Mr. Katz at page 442. And then I'll also refer you, for what it is worth, even though the sequence doesn't work, to what he says in the final report at page 467 and 530. And I'll paraphrase. If the Chair goes to those passages, you will see that Justice Nugent says the following. There have been efforts by people, he says, including Mr. Moyane, to bring this rogue unit thing to this commission. I will not be sidetracked or diverted, I think is the word he used, into investigating that issue. 3, he says, if anybody found any unlawfulness, and in fact he says there may have been unlawfulness in the operation of, he says, about 6 people in the rogue unit. And then fourthly, he says, if anybody finds that there was such unlawfulness, they must go to the authorities. a very good approach by Judge Nugent. In other words, he's saying this is not relevant to my commission. I'm not going to investigate it, and I'm not going to be waylaid into investigating it. And there may or may not have been lawfulness, and if there is such, it must be taken to. So to say under oath that he found it to be lawful is actually, it's just lying. It's untrue. Because he could, when he says it's irrelevant, I'm not going to investigate it, then how could he have found it to be lawful? And when he even says there might be unlawfulness associated with it, but it must go to the authorities. So what we say is that the allegation by Mr. Godan that that Justice Nugent found the rogue unit to be lawful is false, one. Then we say, even if it was not false, that finding, let's assume Judge Nugent made such a finding. That finding cannot overcome the four, remember we're dealing with Mr. Moyane's state of mind. Mr. Moyane could not have been motivated or demotivated by the Nugent report of 2018 and 2015, right? So what did motivate him was the Sikakane report, which says specifically at page 208 that the establishment of the unit is unlawful. It says so at page 208. What also motivated Mr. Moyane is the Inspector General's report, which says that not only is the rogue unit unlawful, but Mr. Godan must be charged criminally. Now, this is the point, Chairperson. Now, you or I or Mr. Pretorius or anybody is the commissioner of Sars sitting there. You have a report from an independent senior counsel that says the thing is unlawful. You have access to a report from the Inspector General, an independent office as well, of some sort, which says Mr. Godan must be charged criminally. You should be fired if you don't then take it to the police and report it, which is all he did. What is worse is that that's actually what Judge Nugent says at 5:30. The same Judge Nugent that they rely on.
Yes, but that goes now to the merits of whether or not he acted maliciously, which belongs down the line.
No, Chair. It goes to the second question, which is whether the Chair should give the, should grant, if you grant the conditionally.
Yes.
My point is that there is no room for the Chair to say, I will grant you conditionally, but you must address what happened in Nugent. Well, Nugent, Justice Nugent, is completely irrelevant to this question of malice. In other words, the Chair, what I'm really motivated for is what we said in our letter is option 3, namely to de-link the leave to cross-examine from from whatever was said. And the final point I was making in that respect, Chair, is that to crown it all, Mr. Moyane did exactly what Justice Nugent said about 3 or 4 times, that if anybody has any information, they must go to the authorities. He went to the authorities, the police. So how on earth can if the Chair at the end of it all is then left with these 2 versions, how can the Chair not be convinced, or rather at least there be no grounds for cross-examination to establish the fact that there are these 4 reports which were operating in Mr. Moyane's mind, and therefore that Mr. Godan is wrong or lying, that he was motivated by malice. For what I'm not now, obviously that will be argued at the end after the cross-examination. All I'm saying now is that that if there can never be more ground for cross-examination.
You see, if we, that's what, so I said earlier on, if in his clarificatory affidavit, Mr. Moyane had stopped.
Mr. Godan.
Nah, Mr. Godan, had stopped on saying, I don't know what was in Mr. Moyane's mind when he laid charges.
Yes.
And I'm not saying he acted maliciously. And if he had stopped there, then it seems to me that that would amount to saying, well, there is therefore no issue that Mr. Moyane acted maliciously, and therefore there is no need to grant leave to cross-examine.
That's correct.
You see. But the problem is that he went further.
Yeah.
And he says, although I say what I've said about malice, I do believe, or what I do mean is that Mr. Moyane abused the legal process, and he abused it in furtherance of the agenda of state capture. That's the part that complicates things. Well, you might say it doesn't complicate
things.
You might say it simplifies. I mean, from the question of principle, as I said, once you say that, for me, the inclination is to grant leave, provided other requirements for leave to cross-examine are met. But of course, he is not, in his clarificatory affidavit, he doesn't say it's because of A, B, C, D that I am saying. He says it's because of these findings that have been made. Now, those findings that have been made on the basis of evidence before the commission, or on the basis of whatever material. And then there is the concern also whether one doesn't then end up opening up the whole inquiry that was before Justice Nugent, But at the same time, I can't make a finding that anybody, or let me not say anybody, I can't make a finding that Mr. Moyane acted in furtherance of the agenda of state capture and make that finding on the basis of what Justice Nugent found, without my own evaluation of the basis and the evidence for that.
Yes.
So that creates the problem, because so
Chair,
you might want to say something about that.
No, Chair.
Now, if we were, I think part of your option 3, I think, it seems to me, if one were to confine confine oneself to the issue of malice without this issue of state capture, it seems to me that's one area. But once you go to the question of saying, did Mr. Moyane act in furtherance of the agenda of state capture, it seems that there is a risk that one is opening up too many things.
No, Chair. Okay, let me try again.
Yes.
The point I'm making, Chair, is that there is no connection between Mr. Godin's evidence here and whatever Judge Nugent found. If it was true and not false and not a lie, that Judge Nugent had found that the rogue unit was lawful, and therefore that then motivated Mr. Godin's evidence, then the Chair would be right. The Chair obviously would say, well, if it's based on this, but if that premise is false, then what has it got to do with Judge Nugent, of the version of Mr. Moyane and Nugent?
So your argument is your argument this, that when Mr. Godin filed his original affidavit, there were no findings by the Nugent Commission, and when he gave evidence before the Commission, there were no findings. There was no final report. I may be getting the facts, timing wrong.
Chair, let me make it easy.
Yeah.
In life, until today, there's never been a finding on the lawfulness of the rogue unit by Judge Nugent. Whether it's this time or that,
no, I'm not talking about the rogue unit.
Yes.
I'm not talking about the rogue unit. I'm talking about the findings to which he refers in the clarificatory affidavit.
Yes. No, I'm saying, though, well, For those findings must first exist, Chair, for you to refer to them. They do not exist. Judge Nugent says, I am not going to investigate this issue. What is that issue? It is the issue that Mr. Moyane went to report to the police, in respect of which Mr. Godan says he was motivated by state capture. So it's like saying, if I can say I was motivated by the Bible, and you find that that thing is not there, then there is no, you can't then say, oh, well, I want your version on a non-existent premise. So the connection between the allegation of Mr. Moyane's state capture motives and the Nugent Commission is false. False. It's manufactured. For the reason that A, Judge Nugent did not make such a finding, could not make such a finding, having said it was irrelevant. B, the final report only came after Mr. Godan testified there. So if those reasons are not enough to show that the two things are not connected whatsoever, then nothing ever will be. Now, if the two things are not connected, then the chair is at liberty, if the chair is still of the prima facie view that there's an allegation of state capture. What we're saying is that the chair is at liberty to grant leave to cross-examine here and now, or after consideration of our arguments. And if that is so, then the third question that arises is what the chair has correctly identified of circumscribing the parameters of that cross-examination. And that, by the way, is also not a mechanical process. You remember when we argued earlier, we said that's what the chair is here for. The reason a judge is appointed to chair the commission is because in cross-examination, of course, counsel might ask and then chair will say, no, Mr. Mpofu, now this is beyond the scope of what we agreed and so on. So you can't circumscribe it mechanically because these issues are intertwined. But obviously, it will also be the duty of counsel to, not through the back door, so to speak,
to try
bring the other issues that, in respect of which there's still some dispute in another court. So, but that's not something you can legislate now. The only question now for the chair is, does Mr. Godan implicate Mr. Moyane in state capture? Obviously, yes. Is it necessary for Mr. Moyane to clear his name in that respect? Obviously, yes. Is it in the interest of the State Capture Commission to know whether Mr. Moyane is furthering state capture or not? Obviously, yes. And if those 3 yeses are existent, then leave to cross-examine must be granted. Obviously, it's in the discretion, we understand that. And I want to clarify one thing, Chair, to preempt what Ms. Leroux might say. I said this the last time, but in the ruling, maybe it looked like it wasn't clear what I was saying. We accept unreservedly that there is no right to cross-examine.
No, you did,
yes,
you did make that
But
clear,
what we do not accept is that there might not be a right to cross-examine, but there's a right to fairness. And that right to fairness, with respect, does not even belong to you, Chair. It comes from the Constitution. So what we demand here is fairness. And so the linkage between cross-examination and fairness, I don't have to make that point. So we insist on our right to fairness. In other words, Mr. Moyane cannot be, somebody cannot come here and say Mr. Moyane is a state capturer, and then that person is immunized from being questioned. I mean, what is that?
So the only issue, as I say it, once you have that situation, is whether Mr. Moyane meets the whatever other requirements for leave to cross-examine.
Yes, well, that's what I've just sneaked into my last address. In other words, the criteria, Chair will remember in 3.3 that, yes, it must be necessary. The Chair must find that it's necessary and that it's in the interest or furthers the objectives of the Commission, words to that effect. Those criteria are clearly there, Chairperson, because it's implication, we know that it's implicated, he's implicated. And then as far as his version, which is really the issue that we've been debating, is concerned, that version, Chair, is contained amply in his affidavit. It was in the explanation of that version that we referred in the first place to Skakane, we referred to KPMG, we referred to Kruon, we referred to IGI. Obviously, we couldn't refer then to the public protector because, again, it didn't exist. But now we can say that on top of that, so there are 5 independent reports that have found the rogue unit to exist, and the worst one of them finds that Mr. Godan is criminally responsible thereof. Rightly or wrongly, that may be debated in other forums. The point here is that a commissioner of Sars, faced with these reports let's take out the public protector, which say there is criminality, when he goes to the police, is he motivated by state capture, as alleged, or is he motivated by his duty? That's really the only issue. And if Mr. Moyane succeeds to clear his name through the cross-examination, establishing that he was motivated by good governance, then that's the end of it.
Yeah.
If Mr. Godan, or if Mr. Moyane fails, and Mr. Godan's view that he actually was motivated by state capture, that's also well and good.
Yeah. Thank you.
So Chair, to round it off,
your first prize is option 3.
My first prize is option 3,
yes.
Chair. If
I don't grant
if you don't grant option 3, then option 2.
Option 2.
Option 2,
yeah.
Chair, yes.
Okay.
Because it's very important, Chair. I don't want to go into some of the broader issues, but this commission is watched by everybody out there, and the issue of fairness is really central to this.
Yeah.
And the Chair may or may not know that there was a general outcry after the first ruling, rightly or wrongly.
Yeah.
But the point is that some of it was uninformed. But Chair, the point is that this, and I must commend the Chair to have isolated this issue. Not that I agree on the other issues. I strongly disagree.
I know you disagree.
I even disagree with the
vigorously.
Yes, vigorously, as the lawyers say. I even disagree on the test that the Chair applied, but that's a debate for another day.
Yeah.
But at least here, the Chair, to your credit, identified an issue which was the clearest, the one in your zone. Because if someone is accused of state capture, it's not like these other ones that might be indirect. No, we had a fight in some place. This one is literally in your province. And with the greatest respect, Chair, the notion that there are people who are beyond cross-examination must be dispelled. Because as Mr. Moyane says in his affidavit, the root of this problem is this notion that there are angels and devils, and that there are people who are state capturers and others are not. This commission, the experience in this commission has shown that theory. If you talk about Mr. Nene, Busasa, even Ms. Munsami, all the so-called angels are not as pure as snow. Yeah. So there must never be a message that says Mr. Godan is above the law.
No,
if anybody implicates Mr. Moyane, whether it's Mr. Godan or my junior, they must face the music.
No, I think well, I would hope that nobody doubts our commitment to fairness.
I can raise my hand.
That doesn't mean that everybody will always agree that decisions we make are fair. And we accept that there'll be times when people disagree. What is important is that from certainly my side, that I do my best to show fairness to everybody within the constraints of time and other resources that we have, and within the constraints of the Constitution and the law. But also to accept that it's fine for people sometimes to disagree and to think differently. But as long as people throughout accept that whatever decisions are made, they are made in good faith.
Yes.
And if there is a decision they are not happy with, it's not because of anything. It's simply because we see things in a particular way, they see things in a certain way. But we are committed to do our best to make sure there is fairness. As I've said before, it doesn't necessarily mean that we will seek to meet any particular person's notion of fairness. It means that we will seek to ensure fairness as we understand it, as we believe most people would understand it, but we accept that we may make mistakes or we may be criticized, and that's fine.
Yes.
Yeah.
Chair, for what it's worth,
Yeah.
speaking for myself, I accept that unreservedly. And Chair, as you correctly say, I think there's also a misconception about the role of commissions. And that is why commissions, unlike judges, you're not
Yes.
sitting there as a judge as such,
Yes,
although we benefit from
Yeah.
that office.
Yes.
And that is why I say we have instructions to review
Yes.
your ruling.
Yes,
Because unlike
yes,
a judgment,
yes.
a commission's findings
Yes.
can be reviewed.
Yes.
And it may be confirmed or it might be
Yes.
changed or not, and
It's
it will
part
not
of the
reflect.
process, yeah.
And I can assure you,
Yes.
whatever grounds of review we have, none
Yeah.
of them will be bad faith or ulterior motive or anything like that. It will be the
Yeah.
the usual grounds of review.
Yeah.
So, while I'm on that subject, I might as well say that we also hold instructions, because another of the four reasons I wanted to raise was that, which is in the papers. One of the reasons why I say the chair should discard the Nugent report is because we say in our affidavit that the witness, Mr. Godan, had an improper meeting with Judge Nugent before the commission started. That is going to be the subject of a complaint that that my client is going to lay with the Judicial Services Commission. Again, that will take its own
Process.
process. Safe to say, Chair, that the Judge Nugent, at page 417, or rather not Judge Nugent, Mr. Godan, at page 417, does admit to that meeting taking place in his own affidavit under oath. And he says, the issue relating to my provision of the substantiating affidavit to the disciplinary inquiry against Mr. Moyane, or the fact that, and this is the important part, a preliminary meeting was held between myself and Justice Nugent at his request before the public hearings of the Nugent Commission. So, again, the JSC might find that that was proper or not proper, but my parting shot is, just imagine if you, Chair, before you started this commission, had a preliminary meeting with Mr. Zuma, for example, about the commission. I mean, there would be justifiably an outcry. So these are some of the issues which will be ventilated by the courts or the appropriate authorities. Yeah.
Well, when the former president came here, I'm sorry.
Sorry, Chair.
Let me not say this.
Yeah.
But let me say that I've heard it said that maybe before the commission started, the commission should have approached the former president on the basis that he was a former head of state and sought his
the person who appointed
assistance in terms of whatever. The commission did not do so, and it has been criticized for not doing so. But for example, I can say that because this is a presidential commission, I do meet with the current president.
Yes.
Because in regard to certain needs of the commission, I've got to talk to him.
Yes.
But he will appear here at some stage.
Yes.
So I just mentioned.
Yes,
that,
no, Chair,
yeah,
that's,
yeah.
thank you. I think that helps also the public, again, to understand some of the nuances.
The nuances, yes.
Chair,
Yeah.
that's correct. I mean, I was in the Marikana Commission. Judge Falam met with the President 100 times. That's not what we are complaining about. If Mr. Godan was either the President or even the Minister of Finance at the time, then the meeting might have been explainable. But he had nothing. He was just a Minister of Cooperative Governance and a witness, a key witness in the commission. So there was no question about having to meet a witness before but again, those are, as I say, those are issues. So that the example of meeting for official reasons, no, that's accepted. And if people see you with the president one day, they mustn't rush and think there's something untoward.
Well, they'll
that we accept.
you don't. Otherwise, if you didn't say that, they would seek they would brief you.
Exactly. Well, I'll take the brief.
You'll take the brief. Okay, I think
those
that's
are our
enough,
submissions, Chair.
Yes,
in short, prima facie view stands, and there is no the delinkage, and therefore the Chair is at large to grant the leave to cross-examine unconditionally.
Yeah.
Well, when I mean unconditional, I mean in relation to the Nugent issue. But obviously, the Chair will will determine his own procedures.
Yeah, no, that's fine.
As the Chair pleases.
Well, I've ended up giving you much more than I should have given you, and Ms. Leroux. Okay, all right. Let me hear Ms. Leroux.
Thank you, Chair.
Ms. Leroux. You have had everything that I wanted you to be able to hear.
Indeed.
Yes.
And Chair, let me start with a preliminary framing submission and then a summary of where I think the debate has gotten to this morning and the options that I think are available to you and why.
Yes.
The first point that has to be made and stressed again is that Minister Gordhan agrees that no one is beyond scrutiny, and he has nothing to hide, and if it will assist the Commission, and if you determine that it is necessary and in the interests of the function of the Commission that he return to be cross-examined, he will obviously make himself available. His opposition to this application on legal advice is not to be understood as anything but that, and he's entirely supportive of the work of the Commission and consistent with its rules is willing to make himself available if that is what you rule, of course. So there's no basis on which to claim that he's somehow subject to other rules. He is entirely prepared to come back and assist the Commission if that's what you would like. The debate this morning also demonstrates that under the title of malice, this application is in fact trying to get you to undo what you've already ruled. And I will take you to your ruling and what was before you at that point in time to demonstrate that.
Of course, you did hear what I said to Mr. Mpofu, which was more meant for you.
Yes, of course.
Yeah, to say if Mr. Gordhan had stopped on talk about malice and said nothing about state capture, maybe it would have been easy to dismiss the application. Okay, but you address that at your own convenience.
Yes, indeed. But Chair, the point is that Minister Gordhan is not saying anything new in his clarificatory affidavits. He
never said, well, Mr. Mpofu might disagree with this, but I'm saying this also not necessarily having refreshed my memory on everything that he said in previous affidavits. But I didn't understand him to have said in his original affidavit that Mr. Moyane had acted in furtherance of the agenda of state capture. Because if he had said that, definitely Mr. Moyane in his answering affidavit would have dealt with that head on. And I doubt that it would have escaped my attention when I prepared my previous judgment. But maybe there is something that when there are so many affidavits, you might miss something.
So let me.
But it's possible that one might might have to read the affidavits in a certain way. So,
And-
so I'm not saying that just because I might not have picked it up, it's not there.
Chair, let me then summarize, because obviously there have been multiple affidavits placed before you from Minister Gordon, and obviously his 3 days of evidence before you under oath. Minister Gordon's position has been entirely consistent throughout this process, and what he placed before you in his witness statement, in his oral testimony, and in the affidavits that were filed in response to your direction, what he has always said is the following. He doesn't know what was in Mr. Moyane's head when he went and filed the criminal complaint that produced 27 questions from the Hawks on the eve of the budget, and criminal charges that were brought and ultimately withdrawn by the former National Director of Public Prosecutions, Sean Abrams. He says that he understands the 27 questions and the charges that flowed from the criminal complaint filed by Mr. Moyane to have been part of a political campaign against him, aimed at forcing him to resign from the position of Minister of Finance. You'll recall his testimony was that he understood that former President Zuma seemed to regret his reappointment, but understood he couldn't be fired. And so there was a campaign against him, and Minister Gordon's belief is that part of that campaign was law enforcement agencies, the Hawks with their 27 questions, and then the NPA with its charges brought and then withdrawn, used the criminal complaint laid by Mr. Moyane in that campaign. So he's only ever repeated the fact that Mr. Moyane was the person who laid the charges when he makes that statement.
You see, if you go back to my judgment, stroke ruling, you will see that there's a part where I say, if you go to certain parts of Mr. Gordon's affidavit, I hope I explained it like this. Maybe I didn't explain it the way I'm explaining it. You know, certainly when you read the affidavit, you found parts where he was saying, you know, the bringing of criminal charges, the prosecution seems to have been part of an agenda, you know, let's call it state capture agenda, okay? But my difficulty was, now I don't know whether he excludes the laying of charges when he talks about things being done as part of the state, the bringing of charges, yeah. In other words, when he said the bringing of charges was part of this agenda, did he include the laying of charges by Moyane? Or did he only talk about the 27 questions, the decision to charge, and not the laying of the complaint? So that was part of the difficulty. And then, bearing in mind a lot of things that had been said in the affidavit about the two of them, in the various affidavits about Minister Gordon and Mr. Moyane, you then say, what are the chances that he is excluding him from this accusation that the bringing of charges was part of the agenda? Then you doubt that he's excluding him. But then when you read somewhere, you say maybe he's excluding him, maybe he's focusing on the Hawks and the NPA. Those are the institutions that he's talking about when he says they were bringing these charges as part of some agenda. And then you are not sure, hence my seeking clarification. You see, that's where I came from. I just had difficulty understanding whether he was excluding him from that.
So, and Chair, I'm indebted to that further clarification of your thinking and your reading of the affidavits. So what Mr. Gordon has always said is the following. He identifies Mr. Moyane as the individual who laid charges.
Yes.
He says, I don't know why he laid those charges. Those charges were then picked up by the Hawks and by the NPA to do 27 questions and bring and withdraw criminal charges against me.
Yes.
And that component of it, so was the part of the campaign to try to force me out. And that's what he clarifies in his affidavit.
Yes.
So he only ever repeats, Mr. Moyane was the origin of the complaint that was then picked up and used by law enforcement agencies, first the Hawks, then the NPA, in the campaign.
Yes.
So all he says about Mr. Moyane is he was the man who walked in and laid the criminal complaint.
Yes.
That's why he says, I don't know why he did that. So on the charges question, which is the only issue that's still remaining for decision, Minister Gordon has said and has only ever said, Mr. Moyane was the person who did that. That complaint was then used in a campaign, and he doesn't say Mr. Moyane was part of 27 questions or charges because he doesn't have any information to that effect. Where he dealt with Mr. Moyane otherwise in his evidence was to say, from the moment he was appointed SARS commissioner, he resisted my authority and then did things at SARS that made no sense to me and now make sense if you understand them in terms of state capture. And in your ruling, you went through all of that and dismissed the application on all of those other topics. What you're being asked to do today is revisit that application and permit that cross-examination, which you've previously disallowed.
Well, let's take it step by step. As you stand there, are you able to say to me, and maybe you have already said so, but I just want to make sure there's no misunderstanding, that Mr. Gordon is not saying that in laying charges against him, Mr. Moyane was acting maliciously, one, or was acting in furtherance of the state capture agenda. Are you able to say that?
Indeed, Chair. So if we look at Mr. Moyane's, Minister Gordon's clarificatory affidavit, under the heading where he's trying to recap his evidence before the Commission and show that it's Mr. Moyane who introduces this idea of malice and poses the question of whether you should entertain the debate about what was in his head when he laid the complaint, Minister Gordon says, my evidence, this is paragraph 10 of his clarificatory affidavit, it starts there. He says, my evidence focused on the overall pressure and political campaign which was part of the efforts to capture state institutions in recent years that I was subjected to following my reappointment as Minister of Finance. I believe that the investigation, that's the Hawks 27 questions, the later criminal charges, that's the bringing and withdrawal of the charges by the NPA, that both originated from Mr. Moyane's complaint were part of that campaign. So again, all he's saying is factually, Mr. Moyane laid the complaint that produced what the Hawks and the NPA did to me in terms of a campaign that Minister Gordon believes was aimed at getting him to resign. That's paragraph 11. If I could be pressured into resigning, I believe that efforts to capture National Treasury by appointing a compliant Minister of Finance in my place would have continued. You'll recall that obviously his reappointment was because of the disastrous appointment of Mr. Des van Rooyen for a weekend, essentially. Then paragraph 12, he takes you back to his evidence before you. And the only time he mentioned Mr. Moyane in relation to the charges was when he testified, and he quotes it, the envelope containing 27 questions addressed to me from the Hawks demanding that they be answered by 2 March 2016. The questions related to the high-risk investigation unit within SARS formed years earlier. Charges against me relating to that unit had been filed by Mr. Moyane on 15 May 2015. Again, it's a factual recording that Mr. Moyane was the individual who laid the charges. He then goes on about the charges being brought and withdrawn, And then in paragraph 17 and following of his affidavit, he says the source of the claim that Mr. Moyane acted with malice when he laid the charges is Mr. Moyane himself, not me. He explains how he dealt with that in his answering affidavit. And then at paragraph 22.5, where he's dealing specifically with your directions on what you want clarified. Because what you wanted clarified was, are you saying that Mr. Moyane, and to quote you, the directive was motivated wholly or in part by, or he sought to advance the objectives of state capture, and that he was abusing a legal process for his own personal goals that had either nothing or little to do with a legitimate complaint relating to an alleged crime. So in trying to respond to those hypothetical options that your direction posed, Minister Gordon says at paragraph 22.5, I believe that Mr. Moyane's personal goals while he was SARS Commissioner included the advancement of the state capture project. The belief is founded on what we know now about the failure of integrity and governance at SARS, evidenced by the change over 4 years, compromising its core function of collecting tax as found by Judge Nugent. And then he turns to highlight, based on the Nugent findings, that those are the basis for his belief that Mr. Moyane's actions as SARS Commissioner were part of the state capture process. And then he says at paragraph 29, because he then goes through all of the Nugent findings, and he records at paragraph 28, that when he came before you, he explained to you the acrimonious nature of the relationship with Mr. Moyane once he was appointed, and Minister Gordon was his executive authority, his boss. And there was this acrimony and there was this resistance to Minister Gordon's oversight of SARS. And he recounted all of the various instances where Mr. Moyane appeared to resist his accountability to the Minister of Finance. And then he says, at paragraph 29, this provides the context to and the basis for my belief that his laying of a complaint against me was something other than the action of a reasonable SARS Commissioner. So he's saying, in light of everything we know at the time where this man was acting in a way to dismantle and restructure SARS and resisting in our reporting relationship my authority, at the time I thought something else was going on here. And now that I have the Nugent Commission reports, it confirms that suspicion that I had that Mr. Moyane may have been advancing the state capture project. That has got nothing to do with the malice question, which is the only issue that remains before you for debate. So again, to recap, Minister Gordon only ever says Tom Moyane laid the original complaint.
Let's try and deal with it this way. So I go back to my question. Are you able, as you stand there, to say to me, Minister Gordon is not saying that in laying charges against him, Mr. Moyane was acting in furtherance of state capture?
Yes, Chair.
Because if that's what you say, I think it may make a big difference.
Yes, Chair. Because
that's what you're saying.
Yes, Chair. So what Minister Gordon has said to this commission in his evidence and in all of his affidavits is Mr. Moyane's dismantling of SARS and his resistance to my authority appears to serve the state capture agenda.
Yes.
And the Nugent Commission has found that that was so.
Yes.
With respect to charges, Minister Gordon has only ever said, I don't know what was in his head, and I don't think, and he has said to you that he doesn't believe that it would assist the commission for you to try to make a finding on that.
Yes.
He has only ever said, Mr. Moyane was the person who filed the charges. So the state capture part of any of the allegation is to say, at the time I had this relationship that where he was resisting my authority, he took decisions and took action at SARS that dismantled and undermined that organization. And I'm bolstered in my belief now, knowing what Justice Nugent has found.
You see, it seems to me that if Mr. Gordon's position is, as far as the laying of charges against him by Mr. Moyane is concerned, he is not saying that the laying of charges was done in furtherance of state capture. It seems to me, therefore, that whatever he may be saying in his clarificatory affidavit about that associates Mr. Moyane with state capture might be relating to other things other than the laying of charges. And if it relates to other things and not the laying of charges, it might mean that the issue of the application for leave to cross-examine that was left undecided can be decided on its own. And then Minister Gordhan might have to make up his mind whether he does want to then come up with something separate, which on my reading of his affidavits, which might be different from Mr. Mpofu's reading, might not have been there. So where he might say, I actually do believe that Mr. Moyane did a number of things in pursuance of the agenda of state capture. Here is the basis for my belief, and I'm willing to come and give evidence. That affidavit gets given to Mr. Moyane. He's able to respond to it, and then everything is clean. You know, it can be dealt with. Everybody knows where they stand and about what, but then it becomes a separate thing. That's part of what I'm thinking now. What do you have to say about that?
Chair, I have two things to say about that. The first is that you are, with respect, entirely correct that the decision can be taken today on the outstanding issue that hangs over from the earlier application, this question of malice, and it can be dismissed. So you can decide on the basis of what you have before you already that this residual issue that was left over for argument and further clarificatory affidavits and submissions can now be decided, and decided in a way that dismisses the application, because all Minister Gordhan has ever said is Tom Moyane was the origin of a criminal complaint that was then used in a subsequent campaign by other people, the Hawks and the NPA. So there is no basis on which Mr. Moyane cross-examining Minister Gordhan helps you, because that issue is now decided.
Of course, if I'm correct in the approach I just outlined, the consequence of that may well be that, therefore, in saying what he said about state capture in his clarificatory affidavit, Mr. Gordhan was saying something that had nothing to do with the issue at hand, because the issue at hand was whether in laying charges Mr. Moyane acted maliciously or as part of the state capture. If the position is that he is saying the laying of charges, he's not saying that the laying of charges was part of furthering the aims of state capture, then really whatever he said might be what he believes, but it therefore might not have been relevant to the issue.
Precisely, Chair.
Yes.
So he says the laying of charges is only, the only reference that Minister Gordhan makes to the laying of charges is to say how it's subsequently picked up by other entities in the campaign to try to get him to resign. That's all he says. In the clarificatory affidavit, where he recaps his evidence about the attack on Treasury and the attempt to capture Treasury and what Mr. Moyane did at Sars, he's trying to respond to the Chair's direction that said, are you saying that there was there was something else going on? And he says, it's my personal belief that Tom Moyane played a role in the capture project based on what he did at SARS, which has nothing to do with charges.
But of course...
And also, sorry, Chair, if I could just complete the point, it's nothing new, because that's what he testified about already, and in your ruling, you went through all of those themes that they hope to cross-examine on, Minister Gordon and state capture, SARS and state capture, the high-risk investigation unit and capture, and you dismissed all of those themes and topics. So you've already decided that the other is not going to be the basis for cross-examination, certainly not without a version from Mr. Moyane.
You see, in the direction that I issued, where I asked whether he meant that in laying charges, Mr. Moyane abused legal process or whatever wording I used, I was talking about the laying of charges and nothing else. Therefore, he should only have responded to that within the context of the laying of charges. But from what you say, it seems that you are saying, as far as the laying of charges, he is not associating that with state capture. But other things that Mr. Moyane may have done while he was commissioner of SARS, there are other things that he is associating Mr. Moyane with in the context of state capture. So my question is, then he shouldn't have bothered to tell me about those, because all I was interested in was the laying of charges. You understand that?
Yes, he may well should not have bothered in going further. But as I've explained, it was obviously a misunderstanding of your direction.
Yes.
It thought that the direction invited Minister Gordon to address the laying of charges issue, which she did, and then where the direction said, what are you saying about Mr. Moyane's role in state capture? And then he clarified again the part that he did. But the critical point for today's purposes is that you have already considered that other aspect and rejected the application. You have already decided in your earlier ruling that it doesn't assist the work of the Commission to have Mr. Moyane's legal team cross-examine my client about why he believes the Nugent Commission, which is essentially what the exercise would be. So he's already explained, and in your ruling, it starts at 42 and continues through the ruling until it goes all the way through the various themes until we get to paragraph 67. That is where, from paragraph 42 all the way to 67, is where your ruling dealt with the unit narrative, the findings of the Nugent Commission, and you determined that it was not going to assist the work of the Commission to have cross-examination on that question.
Yes, but remember that, at least as far as I recall now, and I may be mistaken, none of that was put within the context of state capture. As I understand, I may be mistaken, but what he added in his clarificatory affidavit was quite so clear. Says Mr. Moyane acted in furtherance of state capture. Now, this is the State Capture Commission. If somebody is accusing somebody of acting in furtherance of state capture, surely the Commission wants to hear more about that. But I don't want us to go around in circles.
No, but Chair, I absolutely, with respect, I absolutely agree with you, because for the Commission absolutely needs to hear more about how Mr. Moyane was or was not part of the state capture project. But it must hear it from Mr. Moyane.
Yes, but
It must be a version from Mr. Moyane that deals with his time at SARS, deals with his
Yes.
time at correctional services where he was mentioned in relation to the Bosasa payments, deals with his role in the Waterkloof landing that has also been
No, no,
handled
no,
by the Commission. So there's a version from Mr. Moyane that would assist the work of the Commission.
yes, no, no,
It's
no.
not by cross-examining Minister Gordon on his beliefs based on the Nugent Commission.
I think we should put it this way. Anyone who has information suggesting that anybody was part of the state capture agenda should come forward and bring that information to the Commission. They bring that information by way of a statement or affidavit. Once the Commission has got that, it makes a copy available to the persons implicated therein. They get a chance to respond, and at a certain stage, somebody will give evidence, and applications for leave to cross-examine will be made. But that's what, and then that's where the issue comes up, that if you want to be granted leave to cross-examine, you must put up your version.
Indeed.
You know, so so that's why it may well be that in the light of the stance you have taken, and I think it would be important that maybe there be another affidavit where Mr. Gordon confirms exactly what you have said. It may well be that, therefore, if Mr. Gordon wants to supply the Commission with whatever information that he has personal knowledge of that suggests that Mr. Moyane was acting in furtherance of the agenda of state capture, maybe he can then put that up afresh, and then that can be given to Mr. Moyane. He gets a chance to respond, and we take it from there. But maybe this one can be closed on the basis, and I know Mr. Mpofu is still going to have a right of reply, and Mr. Pretorius hasn't said anything. It may be that if Mr. Gordon says, I'm not saying that in laying charges against me, Mr. Moyane acted in furtherance of the state capture, I'm not saying that he acted maliciously, maybe that should close off one chapter. And then if there is going to be another chapter, then it's a new chapter. Yes.
Chair, Minister Gordon has always said precisely that. He has only ever said Mr. Moyane was the origin of what turned into a campaign. He has already provided to the Commission, relying on Nugent and relying on the evidence he gave you already about his personal experience of what Mr. Moyane did as soon as he arrived as SARS Commissioner, to say this seemed to be a part of the state capture project. So I will obviously take instructions, but I'm not sure Minister Gordon will have further information to help you. But that's the critical point. It's time for Mr. Moyane to tell you and to tell the country why what he did at SARS was not part of state capture. Because he never went to Nugent and explained it. He's never, despite promising you the last time we were here that a review of Nugent would be launched imminently, it's never happened. And now he wants to come to this Commission and try to rerun the same arguments, the same themes, the old narratives that are being used outside of this room to try to discredit my client in a political campaign. And that's public protector reports and IGI reports and the like. And the question for the Commission, when it receives Mr. Moyane's version, is whether it will be useful for Minister Gordon to return on that basis. But for purposes of today, and obviously if you would like a further, and we will keep it very, very short so that it's very, very clear. If you would like a paragraph that says, I've only ever said he was the origin of the charges, Everything else I have said about Mr. Moyane and state capture is based on my personal experiences that I've already testified to, and
Not in relation
what
to the
Nugent
laying of
says.
charges.
Not in relation to the laying of charges.
Yeah.
We could do that, because that would close off this application, and it would mean that once Mr. Moyane finally takes the country into his confidence and says, this is what was actually going on when I was doing what I was doing. And obviously, you would have to decide if you can entertain that evidence, given that you are not sitting as a review court of the Nugent Commission. Presumably,
Well,
he may say something about Minister
well,
Gordon,
well,
and we could have a further application then.
I'm not, and I won't be sitting as a review court of the Nugent Commission, but at the same time, just because Justice Nugent had made certain findings, I can't just accept his findings
No, of
and
course.
make them my own.
No, of course.
If I am to make any findings, I may take into account what he has said, but in the end, I must make up my own mind.
Absolutely.
So there is that, but I think I understand what the gist of your submissions.
Chair, if I could then just briefly correct one factual error made by my learned friend in his submissions, because it's important for the record. So, Mr. Mpofu submitted to you that there was no way, when he was arguing to you that Minister Gordon couldn't possibly have relied on the Nugent reports when he said that this is why I believe there is no rogue unit, and he made that finding. Let's just recall what was in fact going on there. So the allegation against Minister Gordon has only ever related to his role in the establishment of the unit. That's when he was still SARS Commissioner. He then became Minister of Finance for the first time, and as has been clear in the Public Protector review that's pending, never played any role in the functional operation of the unit. He has only ever been said to have played a role in its establishment. In Judge Nugent's interim report, which is dated the 27th of September 2018, which is before Minister Gordon comes and testifies here, at paragraph 36 and 37, Justice Nugent says, I find no reason why the establishment and existence of the unit was indeed unlawful, and I'm supported in that by an opinion given to Mr. Moyane by leading senior counsel in late 2015. He then continues at paragraph 37, what sparked this off was a report in the Sunday Times, and that's the start of the so-called rogue unit narrative. So when Minister Gordon sat in this room, and when he clarified in his subsequent affidavit that his belief about Mr. Moyane's role in state capture, including the disbandment of the unit and the rogue unit narrative that has then been repeated and repeated and repeated despite its falsehood, he was relying on that finding by Nugent, which predated his evidence. It says, I find no reason why the establishment was unlawful, and that's the only part of Minister Gordon's role in the unit that has ever been the subject of any inquiry. So he is perfectly entitled to say, I ground my belief on the Nugent finding, that Justice Nugent couldn't find why the establishment of the unit was unlawful. And this, it's also something that I do have to put on the record precisely because my learned friend astutely recognized that this commission is something that the public is watching, that the country is looking at. And it's to say that the attempt to try to introduce into these proceedings the full narrative around the investigation unit at SARS, not only does it fall outside of your terms of reference, but it runs the risk of this commission losing its credibility and being captured itself when it's used as a platform to run this narrative. Because my learned friend stood before you.
But it's your client who says, look at the Judge Nugent report.
Yes, Chair. So let me be clear what I'm saying.
He's the one who says, look at the Judge Nugent report.
Indeed. But let's be clear what the submission is, what the position is. The position is to say...
Yes, I'm sorry, so that you can address this fully.
Yes.
Your client says, look at the Judge Nugent report. Here are the findings he makes. These findings are relevant to this commission. In effect, that's what he says. And then I say to you, and I don't see you disagreeing with me, I say to you, but I can't just take Judge Nugent's findings and make them mine. I've got to evaluate. I've got to hear evidence. In other words, the moment you say I must look at the Nugent report and its findings and you say they are relevant, you are the one who is now opening
Chair,
the possibility of me having to hear things that were heard by that commission.
Chair, we must keep two things very clear and distinct in looking at this question. The only reason why Minister Gordon references the Nugent Commission is to explain to you the basis of Minister Gordon's personal belief about what went on under Tom Moyane's reign at Sars.
Yes.
An entirely separate question in which the evidence of Mr. Moyane, not the evidence of Minister Gordon, because he's already given you everything he has on this topic, is to say, was what went on at SARS part of state capture? So those are two very different points. Again, Minister Gordon only references the Nugent findings to say that's why I believe that my involvement in the establishment of the unit was lawful, and why all of this narrative that gets repeated and now is used in public protector reports and hate speech proceedings and outside in political rallies is because there is a campaign against me that began when I was reappointed as Minister of Finance and continues to this day. I mean, there's a certain opposition party in this country that seems to make weekly media statements about my client. So it's a narrative that is getting perpetuated outside. That's all that Minister Gordon says about it and why he references the Nugent Commission. It has never been our submission that you shouldn't look at Tom Moyane and state capture. That has never been the submission.
If nobody references the Nugent Commission, maybe I might not look at it.
And Chair, I mean, obviously it is useful. So again, let me try one more time to explain why these are two different points. What went on at SARS under Mr. Moyane and the role that this narrative has played in our politics and the way that it is used by the proponents and beneficiaries of state capture and corruption at national and local government level is an issue that this commission may well be interested in investigating. And it probably falls under your term of reference that deals with the relationship between procurement and the state. And investigating Mr. Moyane and him coming to put up a version and testify and be cross-examined would probably be useful and of assistance to the function of the commission. It is not to allow Mr. Moyane to cross-examine Minister Gordon, where he's only ever given you that second-hand information. And that's the critical point. Yes. So, yes, and I must just again, because my learned friend put it all on the record, I must be given the opportunity to rebut it. He takes you through KPMG, Sikakani, Kruan, Public Protector. Each one of those legs on which Mr. Moyane may well rely have been destroyed. They've been discredited. The Public Protector reports are on review, and they haven't yet been determined, but there is a serious legal challenge to all of them, unlike the promised review of Nugent by Mr. Moyane.
Well, if they...
KPMG is withdrawn.
I'm sorry,
Chair, if I
Ms.
could just complete the point.
No, I don't want to forget this.
Yes.
Please don't forget your points. Is it fair to the Public Protector to say her report has been discredited if the review has not been finalized?
Well, it's been, let me say it has been, it is currently under a serious legal challenge that will be decided in due course.
Yes, so, but it's not fair
so
to
I
say
withdraw
it's
the discredit,
Yes.
I withdraw that. So the legs that Mr. Mpofu referred to, Sikakani report said, I find that the unit was established unlawfully. Judge Nugent says, and I've read it to you, I find no basis for saying that. Judge Nugent has discredited that leg. KPMG has withdrawn its report.
Yes.
The Sunday Times has withdrawn its articles and apologized. Judge Kruan has disavowed his statements in his evidence before Judge Nugent and apologized to the members of the unit. Today, we are heartened when we see media reports that say that the new SARS commissioner is re-establishing this capacity and implementing the recommendations of the Nugent report. So the commission, you will have to decide whether allowing one more repetition of a narrative that is only serving a political campaign and is not actually getting you to the truth of what happened should be entertained. That's not for Minister Gordon to debate.
Yes.
So the question is simply, if Mr. Moyane were to come and give you a version on what happened at SARS, on what happened at the Waterkloof landing, on what happened with the Bosasa payments, as his name was mentioned, that would certainly assist this commission. But that then means Minister Gordon may well be back, but it's in response to a version finally from Mr. Moyane. So this application we submit, there's really only one outcome here, given where we are, which is to dismiss this residual issue. Get a full version from Mr. Moyane on all of the things he could possibly assist this commission with, and then we will see where we stand. And perhaps when he puts that version up, he mentions my client, and the commission will engage with us, and we will obviously assist the commission as much as we can, as Minister Gordon has to date.
Okay.
And that may well be where we end up on this.
Okay.
And Chair, let me, unless there are further questions, I think that's
Yes.
where I should
No,
I should
that's
leave
fine.
it.
No, I have no further questions.
Thank you, Chair.
Yes, let me hear Mr. Pretorius before I can have Mr. Mpofu in reply.
Yes, thank you, Chair. I'll be brief. The factual issues, Chair, appear to be, firstly, why did Mr. Moyane lay charges in relation to the conduct of Minister Gordhan? Secondly, was that part of a state capture project, as appears at least now to be alleged by Minister Gordhan, and I'll give you the references in a moment. And thirdly, was the laying of charges based on reasonable and probable cause, as alleged by Mr. Moyane? Of course, those two issues are not mutually exclusive. It is at least theoretically possible that both were correct, but that is a matter that can be dealt with in the course of time.
Well, as I see it, the question of whether Mr. Moyane acted reasonably and reasonably, maybe also without probable cause, is neither here nor there until you say there was malice, or you say he was acting in furtherance of state capture. In other words, if he acted unreasonably, that on its own doesn't bring that issue within.
Not within your terms of reference. That's the point to which I would now like to move.
Yes,
Chair. Because both are possible. He could have acted with reasonable cause, he could have acted without reasonable cause. The issue for determination within the terms of reference is the allegation as to whether that was part of the state capture project or not. Malice is a label that is placed on the conduct, but it is the underlying conduct, of course, that is important rather than the label which is given to it or its categorization, although it may become legally relevant at a later stage. But may I just put to you, Chair, that there is at the very least uncertainty and confusion about who is saying what. At page 8 of your papers, Minister Gordhan says in paragraph 12, in that quote, charges against me relating to that unit had been filed by Mr. Moyane. Then in paragraph 15 on page 8 rather, he says that entire process of investigation and the bringing and withdrawal of charges against me by the NPA was part of a campaign to capture state institutions.
Yes.
So it seems what Minister Gordhan, subject to clarification, and I'll come back to that point, might be saying, is that the laying of charges was part of a campaign of state capture. It's further clarified in paragraph 31 on page 14, where he says in paragraph 31, considering my interactions with Mr. Moyane over this period and the subsequent findings of the Nugent inquiry, my personal belief remains, and I emphasize the word remains, that Mr. Moyane abused his position as the former SARS Commissioner to institute criminal proceedings against me and others, since there was no reasonable basis for him to do so. And then in paragraph 33, he said, it also served, whether deliberately or not needs clarification, the political purpose of attempting to pressure me and others to resign, thereby advancing state capture and the capture of national treasury in particular. And then if one goes finally to paragraph 22.4, Minister Gordhan says, to use the words of the chairperson's directions, I therefore do mean that Mr. Moyane was motivated wholly or in part, or he sought to advance the objectives of state capture, and that he was abusing a legal process for his own personal goals that had either nothing or little to do with a legitimate complaint relating to an alleged crime. And then he says quite clearly in paragraph 22.5, I believe that Mr. Moyane's personal goals while he was SARS Commissioner included the advancement of the state capture project. So leave aside all that. At the very least, one can say there's confusion about what Mr. Gordhan is saying about Mr. Moyane. That's being a little generous, I think, to Mr.
Mpofu nods.
But the purpose of cross-examination, of course, is to clarify, not only to challenge, but is also to clarify.
Yes.
Of course, that same object may be achieved from a statement of clarification by Minister Gordhan, but that's a decision you will make, Chair. If I may just raise another issue. Of course, these issues are dealt with in a number of other fora and by a number of other instances. In a related way, possibly the Nugent Commission, the Public Protector, and others. This commission is not a review or appeal body and is not here to second guess or comment really in any decisive way, and I stress decisive way. Collateral comment may be possible on those instances. So if cross-examination is to be granted, Chair, it must be A, in accordance with our own rules, and B, based on evidence given before you as Commissioner. So in that respect, there must be a version. Mr. Moyane must clearly state what his version is in relation to all the allegations that might remain at any stage after clarification.
Of course, we have to be clear what
otherwise.
Mr. Gordhan is also saying.
Correct. Correct, Chair. That might alleviate the difficulties that arise out of taking all these issues further.
Yes.
Then, Chair, you raised the issue of narrowing the issue into manageable proportions, given the real constraints of time and resources under which we operate. And, Chair, may I suggest that the formulation on page 1 of your communication to the parties of the 6th of May 2019, 1A, in laying the charges against Mr. Gordhan and others, was Mr. Moyane motivated wholly or in part, or he sought to advance the objectives of state capture?
Yes.
That really is the crisp issue,
Yes.
and no other issue falls within your terms of reference.
Yes.
Finally, just a comment on the point raised about you having made a ruling and therefore not entitled to make any further ruling. It seems clear, Chair, that in the light of the further statements put before you, at the very least, you are free to make a ruling and in fact obliged to make a ruling to clarify any uncertainty, whether by cross-examination or otherwise.
Yes. Thank you, Mr. Mpofu. I've got to restrict you quite seriously this time, otherwise we won't finish.
Yes.
But I'm sure that your response would be quite pointed.
Yes. Chair, let me Firstly, I must, just on a light note, say I'm worried when Mr. Pretorius supports my... the last time he did that, the application was dismissed. Yes,
But I saw that as he was referring to various paragraphs, you were nodding.
yes, I was nodding, but I was particularly nodding when he was saying he's being generous to Mr. Godan. Because, Chair, on a serious note, that really is a correct statement. I do not understand, Chairperson, how counsel can stand here and the Chair asked her twice, are you saying that Minister Godan is not saying that Mr. Moyane was motivated by the advancement of state capture? And her answer is indeed, Chair. How you can do that, Chair, in the light of Mr. Godan's sworn affidavit, which says, as Mr. Pretorius has just read out, at paragraph 22.5, I think, Mr. Godan says, I do say that Mr. Moyane was motivated by state capture motives. I mean, how can we do that, if we take this proceeding seriously? If that is so, if what his counsel is saying now is his new version, well, that's even more reason for cross-examination, because it means he's now contradicting what he says under oath in the affidavit. Because now we must assume that what his counsel is saying is said by him via her. So the new version now is that she says, I only ever said, Mr. Godan only ever said Mr. Moyane was the origin of what turned out to be state capture by others. This is the first time we hear that. What we know is what Mr. Godan said here and what Mr. Godan says here. Remember, and deceptively, the words are taken out from your letter. Mr. Pretorius correctly reads them out properly. Remember, your letter said, the question is, in laying the charges, not in doing something else, in laying the charges against Mr. Godan, was Mr. Moyane motivated wholly or in part by, or he sought to advance the objectives of state capture, and that he was abusing the leavers process and so on and so on. To that question which you asked, Chair, Mr. Godan says, to use the words of the chairperson, that's at paragraph 22.4, I therefore do mean that Mr. Moyane was motivated wholly in part by and sought to advance the objectives of state capture. And his counsel now says, no, he never said that. The only thing he ever said was that he was just the trigger and then others took over. I mean, that's just a lie, a blue lie. And if, just on that basis alone, Mr. Godan should not be given another chance to do another clarificatory affidavit. He must come under cross-examination and tell us which is his version. Is his version the one that he saw under oath here, or the one that his counsel has now introduced, which is that he distances himself from anything that happened after he laid the charges? I mean, really. So this thing will never end, Chair. We'll be here forever. If every time we'll be doing another clarificatory affidavit, another clarificatory affidavit. There is, Mr. Pretorius is quite right. At best, you can say there's confusion. I say there's no confusion. It's very clear what Mr. Godan is saying. And all he must do is either to justify it or not justify it, or withdraw it if he wants, but under cross-examination. And then he must explain why he under oath to God, has said two different things. That's exactly the purpose of cross-examination. Number two, Chair, I must just clarify something. Mr. Moyane said in his affidavits, and in case, he's saying it through me. Mr. Moyane said in his affidavit, he is willing to come and testify here. So this notion that he must come and talk about the Air Force and what, he is prepared to come here. But that's a completely separate transaction. That has nothing to do with his right to cross-examine Mr. Gordhan. So Mr. Moyane can come and testify and assist the commission, and that will take its own course. But right now, he's busy with one thing and one thing only, to apply to cross-examine Mr. Gordhan insofar as Mr. Gordhan has testified. So whether Mr. Moyane was going to testify or not testify, his right or his entitlement to that cross-examination is untouched. The next issue, Chair, is that Mr. Moyane's version. There's this thing about Mr. Moyane's version. Mr. Moyane's version is there, Chairperson. There's nothing for him to come and
the Sekakane report, the IGI report.
No, not yes, that Chairperson, but he puts it very clearly in the supplementary affidavit, page 265. Page 265, he says, remember, this whole debate comes from the supplementary affidavit, and the chair, in your ruling, you actually made it clear, because at first you said, well, he didn't clarify this. And then in his supplementary affidavit, he then, which is what sparked the chair to give this ruling, he then says that he quotes, he does all the things that the chair asked for in the ruling, says how he is implicated, and then says that this means that there's vindictiveness and malice and so on. But more importantly, says at paragraph 13, my version, it's here. So there's no need for him to give another version. My version is, of course, that I was not justified but duty-bound to act as I did, and that any reasonable SARS commissioner in the same position would have done the same. It is therefore my strong case that Gordhan's evidence led before this commission, which implicates me in any wrongdoing, must be viewed against this background and declared to be false, ill-conceived, and very far from being objective or credible. It must accordingly be rejected. I will elaborate further on this aspect when I testify. In other words, there's no requirement, and that's another qualm we have with your ruling, Chair, as an aside. There is this thing that you must put your version or you must reject or whatever is not what I would call the motion court test. That you must now put chapter and verse of every basis upon which you tell the person that you are going to be cross-examining every word that you're going to say. What is needed is a hybrid where you must reject and then say what the basis is. And this is what he did. He says, I reject it because, and we know that goes to the IGI and all those things.
Well, the understanding, and of course, whenever it's relevant, you could make submissions. The general understanding is that you must put your version, you must put a factual basis for what you put in issue and so on, because this being an inquiry, one is quite interested to establish what's common cause and put aside what's not. Yes.
Fair enough, Chair. No, okay. I accept that one can't just put a bold, but I'm saying, Chair, if you go to paragraph 13, 14, 15, 16 of Mr. 16, 17, 18, 19, 20 of Mr. Moyane's supplementary affidavit gives you the version. He says what I've just said, and then says the evidence contained in the answer is freely available in the court. I wish to draw specific attention to two documents referred to, the Sekakane panel and the IGI report. And then it says, in a nutshell, it corroborates my long-held view that inter alias Mr. Gordhan is prima facie criminally liable in respect of the rogue unit, and so on. So the version is here. There's no need, A, to give Mr. Gordhan another opportunity to clarify what is clear, and B, there's no room for the chair to say, Mr.
Well, I guess that if his counsel's understanding of Mr. Gordhan's affidavit goes one way, My understanding of it goes a different way. Mr. Pretorius' understanding of it might be going my way or somewhere in between, or your way, or your way.
Any sane person, Chair, they understand. You just have to read. Even a 2-year-old child will read the affidavit. It says, "I do say he was motivated by state capture."
Yeah.
It's not a question of understanding.
Okay, let's wrap up.
Yes.
Yes.
So, Chair, on that, and this is a crucial point, because, as I say, otherwise this thing will go on forever. Chair, anybody can stand up and say it's Sunday today. Yeah, but
you say it's clear.
It's clear is an understatement, Chair. If a man says, "I do say he was motivated by state capture in laying the charges," what more needs to be clarified, really? What more, Chair?
Yeah.
You know, let's. Otherwise, we'll be clarifying here forever. Remember, that's why you asked for clarification. As I said earlier, Chair, in my submission, even
there was
no equivocation even before. But let's for a moment say there was.
Yeah.
That equivocation was clarified beyond any doubt by Mr. Gordon under oath in an affidavit. If there was equivocation, the one way or the other. So there's nobody who can stand here now and say that he's not saying what he's saying. And as I say, if indeed that is so, he's guilty of perjury. Actually, if he comes with another affidavit that says the opposite of this, we will go and lay criminal charges of perjury, because he'll be lying. Because he did say here clearly what he said. Last point, Chair.
Yes.
The question, this thing about Judge Nugent, I won't elaborate on it because the Chair has correctly pointed out that you're not bound by whatever Judge Nugent said. But even on Mr. Gordon's version, Chair, he says no more than that. He says what we now know, in other words, now in May, whenever he signed the thing, is that Justice Nugent said this and that and the other. So that's completely irrelevant. It's got nothing to do with what he knew when he was sitting here, when the judge gave the he says that in his own words. But again, on this thing of selective reading, this is what Mr. Mr. Nugent said at 243. I have not yet found why the creation and existence of the unit was said to be unlawful, which is how it was consistently and critically depicted. I find no reason why the establishment of the unit was indeed unlawful, and I'm supported by the opinion of Brasiwater. As far as I'm aware, that opinion was never publicly disclosed. And then he says, it might be that some of the activities of one or more of 6 members was unlawful, but that is something else. If that was indeed the case, it is nonetheless incredible that unlawful acts of one or more 6 men led to millions of francs being spent. So he's criticizing the fact that there was more than one investigation. But he says it might well be that there was unlawfulness. And in another report, he says if there is such unlawfulness, it must be taken to the... So to come here and say Judge Nugent found that the rogue unit to be lawful is just another blatant lie. Because he said he did not... You want to investigate it, and if there was an unlawfulness, it should be referred. And he says he has not yet found.
Yeah, I certainly not at this stage. I don't wish to get involved into the lawfulness or otherwise of that unit. But in terms of what I've read, and I can't say I've read everything. But I did look at the part of the Judge Nugent report that relates to that part about the lawfulness of the unit. And I may also have looked at what this is a Sikakane report said, but I'm not 100% sure. But I came out with an impression that was saying it's a pity that at least whatever it is that I had read, and it did include Judge Nugent's report, that there was no analysis of any constitutional provisions or statute to say, this is the statute that says this, this is what happened, and therefore
Yes.
This is the conclusion.
Is this? Yes.
To the extent that I might have seen this Kakane report, I don't remember that it did that. It might have referred to one section of some act, I'm not sure. But I haven't come across any document that gives a proper analysis or detailed analysis to say, to be lawful, such a unit needed to be
To do this and that.
do this and that in terms of that legislation.
Well,
This
Chair-
was done or this was not done, and somebody else saying, but that legislation is not applicable because of this and that and that.
Yes.
But again, that's something I shouldn't bother myself with at this
Well,
stage.
Chair, I will bother you with it a little bit. Yeah. This is what he said. Instead of requesting the departmental intelligence, Kakane, by the way, does do an analysis
Yeah.
of the legislation. That's why he said it's unlawful.
Yes.
But put that aside.
Okay.
In the IGI report, it says, instead of requesting departmental intelligence from the designated agencies as contemplated in the National Strategic Intelligence Act 1994, it was unlawful for SARS to take it upon themselves to establish structures for the collection of intelligence. Such structures existed outside the scrutiny of the Inspector General of Intelligence. It is therefore not surprising that the allegations of impropriety are leveled against the said SARS covert structure. It was on the basis of this that it was concluded that Minister Godan, who was part of the establishment of the unit and knew about its activities, should be charged criminally. So
Okay,
there's
let's
no
leave
doubt
it at
about
that.
that.
Let's leave it at
and,
that.
And that's the first thing. The
Yeah.
public protector also says the same thing. And it's not true.
Yes,
Chair.
let's leave
I
it
have
at
to say this. No. I have to
Remember
say-
that on the issue of cross-examination, that is really neither here nor
Yeah.
the lawfulness is neither here nor there.
Well, and so unless,
No.
only accept it so far as they rely on
She
it.
mentioned, but
Yes.
otherwise, really, it's not, the lawfulness as such
Yes.
doesn't.
Well, the
is not
lawfulness is
something
what
in
must
terms
make
of the issue on cross-examination that we are dealing with.
No, Chair, it can be. The lawfulness, if Mr. Moyane went to lay a charge about something that was perfectly lawful, that's one thing. But if he
Yes.
went to lay a charge about something which was a criminal activity, that's another thing. So it's not irrelevant.
Yes,
So-
but remember, going back to the issue of reasonableness, even if Mr. Moyane laid a charge that Mr. Gordon...
Turned out to be,
It turns out, if he believed that Mr. Gordon's conduct was unlawful, and it turns out to be lawful, that might have nothing to do with state capture.
true. But
You see.
if he had grounds to, if he saw him shooting somebody and went to a police station, then you can't say he's motivated by malice. That's the point I'm making. So,
Yes.
so if indeed there was criminal activity or unlawful activity, and on the basis of that he went to the police, how can you say he's motivated by malice? So it goes to the very nub of
No,
the question.
but you see, I'm moving from this point that even if he didn't have good grounds to lay a charge,
Agreed.
you know, for which you might criticize him in another forum.
Yes.
But for purposes of this commission, that might be irrelevant
Yes.
until you say it's connected with
with
yeah,
state capture.
yeah.
Fair enough.
But yes, but
Chair,
I think let's.
I just
I
have to
understand your
yes.
submissions. Yeah.
The notion, going back to Mr. Moyane's state of mind, it is also not true. Well, fortunately, it was withdrawn to say that the public protector's report is discredited. Sikakane's report is also not discredited. The fact that Justice Nugent says he doesn't see anything, that's his problem. It's got nothing, it's not a discredit. Justice Nugent was not sitting as a review or appeal court of Sikakane. Sikakane stands as we stand now. Nobody, not even Mr. Godan has ever reviewed the Sikakane report, so it stands, right? Kroon, the Kroon Justice, Judge Kroon's judgment, I've said this before when I was here. It's a fallacy to say that it was withdrawn. Justice Kroon sat as one of 7 people. He went to the Nugent report, commission and he withdrew his support for the report. Of the 7 people, so if that's what I said. If there were 7 of them, and let's say Justice Kroon voted against, and the other 6 voted for. The report still stands. So this notion that the Crown report is discredited is also completely a fallacy. The IJI report says he must be charged criminally. It has never been challenged. So all the 4 reports, I'm excluding the public protector, that Mr. Moyane had access to, say the same. And the only report on the other side is one which did not investigate the issue, which deals with it tangentially, and which says that it won't be diverted into looking at it. So, all in all, there is no report that finds the rogue unit lawful. At best, if you twist the language, you'll say there's 1 out of 6 or 7.
Thank you. Let's end the proceedings relating to this application here.
I'm sorry, I was trying to listen to you. Looks like I can't multitask.
Yeah, I'm saying let's end the proceedings relating to the application for leave to cross-examine.
Yes. Okay, Chair.
Yeah.
Can I just say one thing? Otherwise, my attorney will fire me.
Yeah.
Chair, this notion of dragging this thing and further opportunities and endless clarifications will only add to the notion of that Mr. Gordhan is untouchable and is not treated like other witnesses, or that he should not be cross-examined. Let him come and face the music and do his own clarification here.
Yes, let's end it there. I'm going to reflect on the arguments presented and revert to the parties. Yeah, I think let's leave it on that basis. Yeah.
Thank you.
Okay.
Thank you.
So my decision in regard to this outstanding issue on cross-examination will remain reserved.
Thank you, Chair.
Okay.
Thank you very much, Chair.
Okay, I think we'll take the tea adjournment. We'll take some adjournment before we proceed with the other matters. We will resume at 11:45. It's 11:25 now. We adjourn. And then once we have got all of those, then hopefully it will be quite clear where the areas of dispute are.
Yes.
Or there might not be much in terms of areas of dispute. There might be a convergence of views on some of the issues at least. Probably there will still be some issues that will remain in dispute.
Yes, Chair.
Yeah.
Thank you,
Okay,
Chair.
no, that's fine.
Yes.
Thank you very much, Lieutenant General Matakata. You are excused and you will be advised of another date, but thank you very much for coming forward to give evidence. Thank you.
Thank you, Chair. May we also be excused, Chair?
Yes, you are
Thank
also
you.
excused.
Thank you.
Thank you. Let's see, Ms. Wenzel, we are the only ones who are not excused. Yes, good morning, Ms. Wenzel. Good morning,
Chair.
Colonel Naidu.
Good morning, Chair.
Yes, okay. Are we ready?
Yes, Chair.
Yes, let's continue.
Colonel Naidu, when we adjourned yesterday, we were dealing with page 47 of your witness statement, and in particular, we got to the point where you deal with the sale of SR vehicles and New World Motors. Is there something you would like to say about that?
That is correct. Chair, regarding point M, sale of vehicles, the heading New World Motors, Chair, from point or paragraph 195 to paragraph 201, Chair,
Yes.
all that is here in my statement hinges on what I believe or assume how the system was abused with regards to the tender process. So I would not speak on this in detail, but I'm willing to help the investigation team with their investigations regarding this matter.
Okay, no, that's fine. Is that all right with you,
Yes.
Ms. Wenzel?
Yes.
So these issues can be investigated further?
Yes.
And depending on the outcome of the investigation, Colonel Naidu could come back and talk about, give evidence about them, or other witnesses could be called,
Yes,
or both.
yes.
Yeah, okay, all right.
Thank you, Chair. Colonel Naidu, then proceeding from page 49, you deal with what you call a trade-in of General Mdluli's private BMW. Could you explain to the Chair what happened there?
Chair, yes, if I can just give the background as to my own involvement in this transaction. I was given an instruction, this was probably in July 2010, Chair, by General Lazarus to go to General Mdluli's house in Vosloorus to pick up his BMW, his private vehicle at that stage, 730 diesel, and I must take the vehicle to Nissan Atlantis. This I carried out, Chair. I indeed did this and handed the vehicle over to Mr. Jan Venter at Nissan Atlantis. Chair, after about 2 weeks,
I'm sorry, were you told, excuse me, were you told why, excuse me, why it was necessary for you to take this vehicle to Atlantis Motors?
at that stage, no, Chair.
You were not told at that stage.
No, Chair.
Excuse me. And then you say after 2 weeks, what happened?
After 2 weeks, I either got a call or had a conversation with Colonel Barnard. He asked me to collect the BMW from Mr. Venter, who's the dealer principal at Nissan Atlantis, and that I must take that particular vehicle to Leo Haas, where I encountered a Mr. Nico Visser. Chair, Leo Haas is a BMW dealership in Pretoria. Mr. Nico Visser is a salesperson at Leo House, Pretoria.
Okay, before we proceed, let's go back to when you took the car to Atlantis. Did you not have to say why you were bringing the car there, or did you find that somebody knew about, was expecting the car, and somebody had spoken to them about it?
Chair, that is correct. I believe that Mr. Venter, or arrangements rather, had been made with Mr. Venter to receive this car, this particular vehicle. As, like I mentioned, when I picked up the vehicle from General Mluli's house and subsequently dropped it off with Mr. Venter, he did not ask me any questions or whose this vehicle belonged to. So it's my belief that arrangements was made, and I handed the keys over to him and I left.
Yes, okay. Then 2 weeks later, General Lazarus asked you to pick the car up and take it to?
No, Chair, it was Colonel Barnett.
Oh, Colonel Barnett.
That's correct.
Yeah, and asked you to take it where?
He asked me to pick up the car from Nissan Atlantis and take it to Leo Haas. I'm not sure if I'm pronouncing that correctly. It's Leo Haas or Leo Hayes. It's a BMW dealership in Pretoria.
Yes.
And I dealt with a gentleman by the name of Mr. Nico Visser. He was actually one of the salesperson at Leo Haas.
What's the name of the gentleman?
Nico Visser.
Okay, Visser.
That is correct, Chair.
Okay, yes.
The reason that Colonel Barnett gave me regarding picking up the vehicle from Mr. Venter and taking it to this particular dealership is that Mr. Venter was battling to get a decent price, or they were struggling to sell this particular vehicle at Nissan Atlantis. That was a reason that was told to me. And I'm referring now to Mr. Visser of Leo Haas, after me taking the vehicle to him.
So you picked it up from Mr. Venter and took it to Mr. Visser?
That is correct, Chair.
Okay.
Mr. Venter being the dealer principal of Atlantis Nissan, and Mr. Nico Visser being the salesperson at Leo Haas BMW.
Yes, okay.
Mr. Visser did the appraisal, Chair, and he informed me that the windscreen was cracked, and he suggested to me that the windscreen be replaced or should be replaced, as this would affect the value of the vehicle. Chair, I'm not sure if this was ever done. I can't recall.
Yes.
What I can say, though, is General Mluli's private BMW was eventually sold. I say this because Colonel Barnett asked me to make contact with General Mluli because the salesperson, Mr. Nico Visser, wanted the spare key.
Wanted?
The spare key. The spare key, Chair. I believe the keys are quite expensive, so he wanted the spare key. I contacted General Mluli, Chair, and I managed to obtain the spare key from him. I also recall when he handed over the key to me, and I'm referring to General Mluli, he remarked or said something to the effect that I'm giving you the key and I'm getting nothing in return. This was quite light-hearted, Chair. It was almost like a joke.
Mm-hmm.
I then relayed this message to General Lazarus, also light-hearted on my side. And General Lazarus, I remember him saying, does he know how much we spent to sort out his car? This is what General Lazarus said, referring to General Mluli.
He said, does he know what?
Does he know how much we spent to sort out his car?
Oh, okay. Talk about the same car.
That's correct, Chair.
Okay.
Chair, at that stage...
At that stage, you also didn't know, or did you know, how much had been spent on this car?
I'll speak about that in my next, in the next paragraph, Chair.
Yes, but tell me whether you knew at that stage or not.
No, Chair.
Yeah, okay.
And I'm speaking about the same meeting or same conversation that I had with General Lazarus. He had a page on his desk, Chair. It was a few figures written. I think it was 3 different figures that he showed me, and he gave me the page, and he told me to go and show it to General Mluli to show him how much they spent to sort out the said vehicle, the transaction, or rather the shortfall. Chair, I did not show General Mluli this page that was given to me by General Lazarus. I shredded the document, Chair.
Yes. Ms. Wilson?
Chair,
Yeah.
if I can continue.
Yes.
After I collected the key from General Mluli, I went over to Leo Haas and handed this key to Mr. Visser. Chair, after this transaction concluded or was concluded, General Lazarus told me that I must organize or make arrangements for a loan agreement to be drawn up between Mr. Jan Venter of Nissan Atlantis and General Mluli. The reason given to me by General Lazarus was that there was a shortfall of 50,000 Rand on the transaction on General Mluli's private BMW. Chair, at this stage, I do not know why the instruction was given to me to draw up an agreement between Mr. Visser of Atlantis Motors and General Mluli, because the vehicle was actually sold through BMW, Leo Haas. So at this stage, I don't know why this instruction was given to me. However,
Yes.
I can say that the document was drawn up, Chair. There were 3 different documents, Chair. I'll now refer to the first one. I'm referring now to the acknowledgement of debt between General Mluli and Mr. Jan Venter of Atlantis Motors regarding the sale of his BMW.
Yes.
Chair, during or rather, let me go back regarding the acknowledgement of debt. I think this was about around July 2010, where I went to Mr. Venter on the instruction of General Lazarus and asked him to have a loan agreement drawn up between himself and General Mluli regarding the 50,000, as I explained to previously. This is now the first document I referred to. I said there was 3 different documents, Chair, and I referred to the acknowledgement of debt. This is the first one I referred to.
Yes.
Now I speak on the second one, or rather the first one again. The document was indeed drawn up by Mr. Venter, but at that stage, Chair, it was not signed. So basically there was no legality to that document because neither Mr. Venter of Atlantis Motors nor General Mluli had signed that document. However, what I can say regarding the first one, the first acknowledgement of debt, during late 2010, General Lazarus reminded me or asked me, this is now when crime intelligence got wind of the Hawks investigation into General Mluli's activities. General Lazarus reminded me, Chair, of the agreement that was initially drawn up, which I had actually forgotten about because it was a few months later. But after having checked in my bag and looking for it, Chair, I indeed found this document, and like I said, it was not signed. I then showed this document to General Lazarus. He instructed me to get it signed by Mr. Venter and General Mluli, which I subsequently did. And after the document was signed, I'm not sure if I gave it to Mr. Venter or I kept it in my bag with me. I can't recall exactly.
Do you have a copy of that document?
I'm just going to refer to the annexures.
If you have a look at Annexure DGN 11, page 118, Is the document part of those annexures?
Chair, I don't see that document here. I'm not sure. The document is not here. There's two other documents which are referred to as acknowledgement of debt. There was three, I said. There's only two. I don't see the first one.
So can you assume that you may have given this document to Mr. Venter?
This is, it could be with Mr. Venter, or it could be with Colonel Roloff, sir.
Yes. Thank you. You can proceed.
Chair, this is now the first document that I referred to. I now go to...
I'm sorry, what page is that document?
Chair, it's not in the bundle.
Oh, I thought I missed it.
Chair, it's not in the bundle.
Okay, all right.
Chair, I now go to, and I'm speaking on the acknowledgement of debt, page 118.
Yes.
The next year. This is the second document that I refer to.
And how did it arise that you came into possession of this document?
Chair, this was a period, it would have been probably between June 2011 to October 2011. This was a period when General Mgluli was suspended, Chair. Chair, on paragraph 210, I'd just like to clarify something. It reads, subsequent to General Mgluli's suspension, on the instruction of General Lazarus, I went to General Mgluli. Chair, that is incorrect. General Mgluli, via another member from CI, made contact and requested that I see him. So this was not the instruction of General Lazarus. This was a request by General Mgluli for me to make contact and to see him. But I did inform General Lazarus of the request, and he then allowed me to meet with General Mgluli. So we basically had knowledge of this meeting. Chair, I then made arrangements to meet with General Mgluli. I think it was the Nando's. We met in a car park in the Nando's, the Boksburg area. He handed me a handwritten document and he instructed me to take that document to Mr. Venter, which I did. Chair, now referred to the third document as Annexure 119, or rather page 119.
Yes.
Pardon me.
Yes.
Yes, you can explain this document, Colonel Naidu.
I showed this document to Mr. Venter.
Do you mean the document on page 118?
Page 118.
Yes.
I showed this document that I picked up from General Mgluli, and I showed it to Mr. Venter. He had a look at it, and he said he told me that he will drop a new agreement. This is now referred to the third acknowledgement of debt on page 119, Chair.
Yes.
Chair, when this document, and I referred to the third one, when it was ready, I got a call from Mr. Venter. He told me that he had the documents prepared. I went to his dealership in Centurion. I picked up that document. I made arrangements to meet General Mgluli, again at the car park in Nando's in Boksburg. He signed this document, Chair. I took it back to Mr. Venter. He had it signed, or he signed the document, and I subsequently made arrangements with General Mgluli's son to meet me at the Total Garage in Centurion, and I handed over this document to him. This is now the third one, Chair. I refer to the third acknowledgement of debt.
Yes, and Colonel Naidu, can you explain then what happened in April 2011?
Chair, in April 2011, I was on leave. I had undergone an operation. I was off work for 3 months. I was visited by 3 members of the asset forfeiture unit. They explained to me that they were investigating some activities regarding General Mdluli, more especially the vehicles. Chair, I had a discussion. They requested an affidavit from me. I explained to them that I was on leave, and at that stage I couldn't give them an affidavit until I got permission from my superiors. On that same day, Chair, I went to, while I was on leave, I drove to Pretoria to General Lazarus's office and explained to him that these 3 individuals, or rather the visit of these 3 individuals to my house and requesting an affidavit from me. Chair, it's then that General Lazarus informed me that General Mdluli's private BMW had eventually been sold or traded in when CI purchased 2 BMWs to offset the shortfall on General Mdluli's private vehicle.
Can you explain that?
Chair, for the purposes of explaining it, if I may, let's not call it a trade-in. I'll get to that in a moment. Let's just say that General Mdluli sold his car or his vehicle to Leo Hayes. So basically, in essence, he took this vehicle, it was appraised, and there was a shortfall of 90,000 rand, if I can remember correctly. 90,000 some change. So there was no trade-in. So in effect, if that vehicle was purchased by Leo Hayes, General Mdluli was in debt because they would have settled the car because there was an outstanding hire purchase on this vehicle. So he would have either owed Leo Haas 90,526 rand and 1 cent, or he had to settle the hire purchase on his vehicle. I'm not sure how that would have unfolded. But eventually what happened, now we call it a trade-in because what happened was CI eventually bought 2 vehicles, namely a BMW 330 diesel and a BMW 530 diesel. Both were 2010 models. Basically, now I'm saying this is a trade-in because these vehicles basically were bought, Chair, to offset the amount that was owing on General Mdluli's private BMW.
And how did that work? How does buying a car offset the amount, the balance owing?
Chair, how I am given to understand this transaction, if I can explain it, basically there was no need for CI to purchase these 2 vehicles. They were purchased solely to offset the 90,000 rand that was owing on General Mdluli's vehicle. So the loss actually was not only 90,000 rand to crime intelligence, but also the purchase of these 2 vehicles. I'm not sure at this stage what their value was, but that's what would be the loss to crime intelligence. It would be the value of these 2 vehicles and the 90,000 rand, because this would have been, if CI had bought these vehicles purely for their use or in normal circumstances, that discount of 90,000 rand would have actually gone to crime intelligence. In this case, it went, or rather offset the 90,000 rand that was owing on General Mdluli's private BMW.
Colonel Naidu, I'm not sure if the chair can understand that explanation. So can we just unbundle it slowly?
Sure.
Well, maybe let's do it this way. You took General Mdluli's BMW to Leo Hess.
That is correct, Chair.
Yes. You didn't know at that stage what the purpose was for this vehicle to be taken there, is that right?
No, Chair.
But you found when you arrived there that it appeared that there was some understanding by the people there what the car was there for. Is that right?
That is correct, Chair, because an appraisal was done by Mr. Nico Visser.
Yes. Now, you say that at a certain level for the initial stage, we must take the position to be that the vehicle was there for sale to Leo Hess by General Mdluli.
That is correct, Chair.
And then later on, you say we can then take it as a trade-in. Is that right?
That is correct, Chair.
Let's talk about the first part. In the discussions that you had with Mr. Visser, is there anything he said which suggested that this car was being sold to them?
No, Chair.
No. Well, did the discussion that he may have had with you reveal that the car was being traded in with them?
Not at that stage, Chair.
Not at that stage?
No.
Okay, but he did talk about the fact that the crack on the windscreen would devalue the car.
That is correct, Chair.
Okay. And then you say later on, Crime Intelligence bought 2 vehicles. Is that right?
That is correct, Chair.
They bought them from Leo Hers.
That is indeed correct.
And do you have how much those vehicles, what their prices were?
Chair, it was, I don't have the exact amounts because I don't
Yes.
have the documents, but it was a 2010 BMW 330 diesel and a 2010 BMW 530 diesel.
Yes. Were they brand new cars?
That's correct, Chair.
Okay. And you said also that when General Mdluli's vehicle was taken to Leo Hers, it had not been paid up in terms of hire purchase or credit agreement.
Not at that stage. I wasn't aware of it, Chair.
You were not aware at that stage?
No, Chair.
But you subsequently got aware?
That is correct, Chair.
And when you subsequently became aware, is the position that you became aware that there was an amount of, is it 50,000 rand outstanding that was still to be paid?
That is what was told to me by General Lazarus, Chair.
Okay. So when you heard about the purchase of the 2 vehicles by Crime Intelligence, okay, you said these were bought from Leo Hers.
That is correct, Chair.
Yeah. How was there a connection between the buying of those 2 vehicles and General Mdluli's vehicle being at Leo Hers?
That is correct, Chair, because those, like I said, there was a shortfall on his private vehicle, which was 90,526 1 cent. So these 2 vehicles that are mentioned basically offset or rather, let me put it this way. The 2 vehicles purchased by Crime Intelligence, the 90,000 Rand, 526 and 1 cent would have been a discount to Crime Intelligence. Crime Intelligence did not get that discount, Chair. Instead, it was offset against the outstanding value or outstanding debt against General Mdluli's private BMW.
So in purchasing the 2 vehicles, you say Crime Intelligence was entitled to a certain discount.
That is correct, Chair.
And instead of Leo Hers giving them that discount, it didn't give them the discount, but the money was taken to be part of the trade-in price of General Mdluli's car.
That is correct, Chair. It offset the outstanding amount that was owing on General Mdluli's private car.
Okay. So how would this have been reflected in the books of Leo Hayes? Do you know?
I don't have an idea, Chair. I was not privy to that.
The discount that was not given to crime intelligence, was that a discount that was always given to, or that was generally speaking given to crime intelligence whenever they bought vehicles from Leo Hayes?
Chair, I don't know how the deals took place, but I believe so because I refer back to the discussion that I had with General Lazarus. He said those two vehicles were purchased to sort out the shortfall on General Mdluli's vehicle.
Okay, Ms. Wenzel.
Colonel Naidu, can you explain then why at the end of these transactions there was an acknowledgement of debt between General Mdluli and not Leo Hayes, but rather with Mr. Jan Venter of Nissan Atlantis?
Chair, I'm really not sure why, because the vehicle was actually traded in at Leo Hayes, and I don't know why that the acknowledgement of debt was between General Mdluli and Mr. Venter. I can't say for certain.
And Colonel Naidu, do you know what then happened to the two BMWs that were purchased?
Chair, the one vehicle, namely the 330 diesel, was handed over to FM24 for use. FM24 is a close associate of General Mdluli, and the other 530 diesel was used by General Mdluli himself. Chair, I must add also, at this stage, General Mdluli already had two vehicles in his possession, state vehicles, SR vehicles.
Now, the vehicle, the General Mdluli vehicle that we are talking about, that you took to initially Mr. Venter and later Mr. Visser, that was his personal car.
That's correct, Chair. That was a BMW 7 Series.
Now, in order for General Mdluli's personal BMW to have been taken as a trade-in, General Mdluli would have had to be given a personal car by Leo Hayes, isn't it? Because if he was trading in his personal car, that would mean he is buying another car, another personal car, isn't it?
Chair, that's why initially I said let's call it a sale, as there was no trading, because that's what it was, because he was not buying another car. He was basically selling the car off to Leo Hayes, and that would have been the outstanding debt of 90,000 rand.
Yes.
And then I went to the second part and I say it eventually became a trade-in because there was a trade-in. Crime intelligence bought two vehicles against that BMW, and the outstanding amount was offset against the purchase, or rather the purchase of these two vehicles offset the outstanding balance on General Mdluli's car. So that is why I said initially we'll call it a sale with no trade-in, but it eventually became a trade-in because two vehicles were purchased.
But I don't understand why General Mdluli would trade in his personal car for the benefit of crime intelligence, because the other two cars, as I understand the position, that were bought by crime intelligence in this regard were going to belong to crime intelligence?
Chair, Chair, the benefit was not to crime intelligence, the benefit was for himself, because he was selling his car and he still had to settle the debt of 90,000 some change.
Yes, but you are not saying that his car was then to be sold and he was going to get any money out of that.
He didn't get any money out of it, Chair.
Yes.
And I refer back to, let me go back to where he, I'll refer you to 206.
Page 206.
Rather, paragraph 206.
Yes. Yeah.
Where I say I collected a spare key from General Mluli, and he remarked, I'm giving you the key and I'm getting nothing in return.
You see, General Mluli, when his BMW was taken to Leo Hess, if on his credit agreement with the relevant bank owed a balance of 90,000 rand, and he arranged that crime intelligence should buy 2 cars, but that the discount which should have been given to crime intelligence should not be given to crime intelligence. Instead, it should be given to him because it should be used to settle his balance with the bank for the BMW. If that is what happened and the BMW remained with Leo Hess and became their car, then and these other cars were crime intelligence official cars, it seems to me that he sold the vehicle to Leo Hess for 90,000 rand, which should have been for the benefit of crime intelligence, but it was used for his benefit. Am I way off the mark?
Chair, I'm not sure how I explained it.
Because, you see, you are not saying that he asked for any balance from Leo Hess for the vehicle, isn't it? You don't know anything about any balance.
Chair, there was an outstanding balance of 90,000 rand.
No. I'm not talking about that balance.
Yes, Chair.
You see, as I understand the position, if I have a car which is still under a bank, I can't sell it to you without the consent of the bank. If I sell it to you without the consent of the bank, that agreement is illegal. But the bank can give their consent. And if I still owe the bank 90,000 rand, and the value of the car might not be 90,000 rand, it might be 200,000 rand, might be 150,000 rand. So I might then say, well, you must pay me 150,000 rand, and when you pay me that, I take 90,000 rand and I pay the bank. But it may be that for X, Y, Z reasons, I say to you, if you can give me the 90,000 rand that I owe the bank, that balance, if you can pay it, then then you can have the car. I don't want anything on top of that. I just want to get out of this obligation. You see, the ownership of the car gets transferred. So if Leo Hess was to keep the vehicle, the BMW, and the value of the BMW was more than 90,000 rand, so it may be that Gerald Mdluli effectively sold the car to Leo Hess for 90,000 rand that Leo Hess had to pay to the bank. Or am I causing you more confusion? Am I causing you more confusion?
Chair, as I
will let Ms. Wenzel, maybe
Yeah.
she might give clarity.
Yes, Chair. That's, as I explained, that's how I understand this transaction, how it unfolded.
Yes, but if it unfolded the way that I'm explaining it, then it might be a misnomer to talk about a trade-in. It might be that it was simply, for all intents and purposes, a sale. But crime intelligence being prejudiced in the process, I think Ms. Wenzel is dying to say something. So, Ms. Wenzel, you might wish to say something or clarify or ask questions that will bring some clarity.
Yes, Chair. Chair, the way that I understand it, this transaction can only make sense in the following scenario. And Colonel Naidu, you must tell me whether you understand it in the same way or not.
Sure.
Very sadly, when one buys a brand new vehicle, they say the minute you drive it out, you immediately lose value on that vehicle. So one is often in a situation where you owe more on a car than you are offered in a sale. So if, for instance, the amount owing was 600,000 on the car, but Hearst were only prepared to pay 510,000 for the car. Essentially, you are correct, Chair, an amount of 510,000 needed to be paid to General Mdluli, who would then pay it to the bank. But it may have been, and one doesn't know, whether that happened or whether the 510 was paid directly to the bank, because in essence there was no equity in that car at all. So at the end of this transaction, there was no equity, and in fact there was a 90,000 shortfall.
That is correct.
And so in order to settle that shortfall, the discounts on purchases of 2 new vehicles was offset against that.
That is correct.
Is that correct?
That is indeed correct.
Let's proceed. I think I'm not the only one who doesn't understand what this is. Yes.
Chair, if I may, I've given statements to this regard to Colonel Roloff, sir. He'd probably have more insight in his investigations if that would help.
Yes, okay.
Thank you. Colonel Naidu, can we then deal with the discounts given to crime intelligence members for the purchase of private vehicles by Nissan Atlantis from page 52 of your witness statement?
Yes, Chair. I purchased a private vehicle from Mr. Jan Venter of Atlantis Nissan. The discount that I received was 30,000 rand.
Yes.
My wife's niece also purchased a vehicle. She also received a discount of 30,000 rand, Chair.
How did you arrange these discounts?
Chair, I approached General Lazarus. This was probably in 2007, and I informed him that I wanted to replace my wife's car or trade it in. General Lazarus then directed me to Colonel Barnard and see how he could help me. Colonel Barnard then said to me that he would speak to Mr. Venter to arrange a vehicle for me. or if he could arrange a vehicle. Chair, what I can remember is that I did eventually, or my wife eventually purchased a vehicle, Honda Civic, from the Honda dealership. It's still within, the Honda dealership falls within the wing of Nissan Atlantis. It's one of the dealerships that belongs to Nissan Atlantis. It was a Honda Civic, and the discount I received on this vehicle was 30,000 Rand. Chair, in the same process that I just explained, my wife's niece also purchased a vehicle from Nissan Atlantis, and she also received approximately 30,000 Rand discount.
And as far as you are aware, did General Lazarus also receive discounts for private vehicles from Nissan Atlantis?
Chair, General Lazarus bought two VW Golfs, Kia Picanto, Honda CRV, a Nissan Murano, two quad bikes, a scooter and motorbike through Nissan Atlantis. Chair, I'm not sure what the total discount that he would have received on all of these vehicles that I mentioned.
And then, Colonel Naidu, could you deal with the purchase of the CDTI grey Honda Civic by General Mpluli?
Chair, this was also a vehicle from Mr. Jan Venter of Nissan Atlantis. Chair, this was a 2.2 CDI. It was a grey Honda Civic. From what I can recall of this incident, Chair, this was initially a vehicle that was given to General Mloli's wife. This is now a private vehicle just to test drive. However, the vehicle was driven by General Mloli's wife at that stage for a few months. I say this because I remember having a conversation with Colonel Barnard, and he told me that he was getting a lot of pressure from Mr. Venter because the vehicle was not returned to Mr. Venter, and there was no payment forthcoming regarding this vehicle. Simply meaning that this vehicle was being driven by General Mloli's wife for a few months without paying for it. Chair, I don't know if this vehicle was indeed returned to Mr. Venter or if it was paid for by General Mloli or his wife at that stage.
And did you have any other dealings with that vehicle?
Yes, Chair. I recall an incident where General Mloli asked me to fetch this vehicle from his house and take it to Nissan Atlantis for his service. And also on another occasion, there was that the rim was damaged, and there was a few other things that needed attention on the vehicle.
And
The
what
total.
happened?
Sorry, Ms. Benzo.
No, yes?
The total amount for the repairs of that vehicle was 2,485 Rand. Chair, the invoices were shown to me with my signature on it, but for the reasons of it, these invoices were generated by Company X, so it's not annexed.
Okay.
So, what happened about the invoice?
Chair-
Who paid that?
I contacted Colonel Barnard about the payment. Colonel Barnard said that he will deal with it. I'm not sure, I can't say for certain that it was paid, or if it was paid, how it was paid.
Yes, and Colonel Naidu, can you then deal with your private purchase of a VW Golf R32?
Chair, this was not a private purchase. This was a vehicle that was bought and paid for by the Secret Service account, and subsequently I made use of this particular vehicle. Chair, if I can just give you some insight as to how this transaction came about. Chair, during 2011, at that stage I was driving a silver Golf GTI, which was still in fairly good condition. The kilometers were quite low. It was probably around 40,000 kilometers, and it was in good condition. Chair, around April or May 2011, I was in the company of Colonel FM11. I remember it very clearly, Chair, because this was the period where I was off sick from work. I'd undergone an operation. It was from the 1st of March to the 1st of June, so I was at home. I remember Colonel FM11 picking me up from home. I can't recall where we were driving to, but we were driving in the Boksburg area when we passed the dealership, Chair, S4 Auto, when I noticed a Golf R32 for sale. Chair, I subsequently informed General Lazarus about the vehicle and indicated to him that I wanted to purchase, or rather wanted CI to purchase the vehicle for me to be used as a SR vehicle. Simply meaning, Chair, I wanted General Lazarus to replace this R32, or rather replace the Golf 6 that I've been driving at that stage with this particular vehicle that I mentioned, which was the Golf R32.
Yeah.
Chair, I'm not sure if it was still within this period that I was on leave or off sick. Colonel FM11 drove to S4 Auto, where I met with General Lazarus and FM12. Chair, we inspected the vehicle, but that particular vehicle, Chair, was not in very good condition, so that vehicle was not purchased.
Yes.
Although I informed, or Colonel FM11 informed me that he would continue to look for that particular vehicle in another province. He would speak to his contact in Durban to see if his contact could source one there. Chair, I'm not sure of the time period, but I can say that some stage later, Colonel FM11 informed me that his contact in Durban had indeed managed to locate a Golf R32. We made arrangements. When I say we, it was myself and FM11. We made arrangements to fly to Durban. I'm not sure if we drove to Durban or flew to Durban, but his contact made arrangements for us to inspect this vehicle. Chair, the person that I referred to, the contact of FM11, I remember his name as Lalu. I can't remember or recall his surname, Chair.
Yeah.
He informed us that, pardon me, Chair.
Was it a man or a woman?
Chair?
Lalu, was it a man or a woman?
It's a man, Chair.
Okay.
He informed us that the owner wanted 240,000 for the Golf R32. After inspecting the vehicle and seeing that it was quite in good condition, it was actually in better condition than the one that we had seen earlier or a few months earlier at S4 Auto. I'm not sure if it was me or Colonel FM11 told Lalu that we were interested and that he should speak to the owner and tell the owner to keep the vehicle for us and not to sell it. Chair, on my return to Pretoria, I informed General Lazarus that FM11 and myself had seen this particular vehicle and that it was in good condition and it was in better condition than the one that we had seen previously, and that I wanted it. Chair, General Lazarus gave me the go-ahead to purchase the vehicle. With regards to how the purchase or how the transaction would unfold, Chair, he asked me to speak to Colonel Barnard. At that stage, Colonel Barnard was the head of the procurement section, and he asked me to speak to him and see what the best way would be to purchase this particular vehicle. Chair, before meeting with Colonel Barnard or having a conversation with Colonel Barnard, I remember meeting with Colonel FM11, Chair, and I suggested to him that, to Colonel FM11, that we inflate the price of the vehicle by 40,000 rand. Seeing that
Another 40,000, yeah?
Yes, 40,000.
Yeah, no, these people like
Yes.
40,000 rand. Yes.
Chair, I suggested this to FM11, seeing that the previous vehicle that we had inspected in Johannesburg, S4 Auto, was selling for 280,000, and the vehicle that we inspected in Durban was in much better condition, and it was 40,000 rand less. So this was my suggestion to FM11 to speak to Lalu, and that he should speak to the owner and see if he can facilitate that for us. I informed FM11 that I needed the 40,000 extra to pay for some of the renovations that I was undertaking at that stage at my house. Chair, Colonel FM11 agreed to check with his contact, Lalu, to speak to the owner to see if this deal could indeed be negotiated. Chair, FM11 subsequently informed me that he did speak to Lalu, and the arrangement that we suggested to them could be facilitated. Chair, this would be done once the vehicle was sold and the owner was paid. Colonel FM11 or myself, through Lalu, would fetch the extra 40,000 rand in cash. Chair, I had already previously spoken to Colonel Barnard as to how we would facilitate this deal. Colonel Barnard informed me that it should be done through Nissan Atlantis. Chair, at that stage, Nissan Atlantis was a supplier to Company X. The arrangement was that Nissan Atlantis would pay for this vehicle at the full price of 280,000 rand. And Company X would be invoiced for this vehicle. So basically what it means is, on paper, it shows that Company X bought the vehicle from Nissan Atlantis as opposed to the real owner in Durban. Chair, like I explained, whilst this whole process was going on, I also started renovations at my house, as my wife was going to leave work and we were going to start a business from our home. I remember one afternoon, whilst traveling from work, General Lazarus was with me as he would normally travel with me. He asked me how the renovations were going and if I had enough money. It is then I recall, Chair, that I told General Lazarus I was going to use the money from the sale of the R32 to sort out the renovations. General Lazarus was aware of this transaction, Chair, and my exact words to him were, I'm going to jack up the price of the 32 by 40. Simply meaning, Chair, I was going to inflate the price of the R32 by 40,000 rand.
Yes.
Chair, when I told General Lazarus this, he was not upset or angry in any way, nor did he reprimand me in any way. In fact, he nodded his head, which indicated that he was okay with what I just told him. Chair, at a later stage, FM11 and I went to Durban and met Lalu at a shopping center. I can't recall the name of the shopping center. When we arrived there, I sat in the car, Chair, and told Colonel FM11 to go ahead and meet with Lalu. On his return, Colonel FM11 handed me a money bag and said it's sorted. This, I believe, Chair, was the money that was the inflated price of 40,000 rand on the initial, on the purchase of this specific vehicle. I did not open or count the money, Chair. I told FM11 that he must keep the money with him as he still needed to settle the outstanding modifications done to the car by Lalu. There was some other stuff that was done, Chair. I think there was some modifications done to the exhaust, and the mags were replaced. I can't recall exactly. But eventually, what happened, Chair, after reconciling all of these payments, there was 25,000 rand left over from the 40,000 rand, Chair. At that stage, when Colonel FM11 was handing me over the cash of 25,000 rand, he told me that his washing machine had packed up and that he needed to buy a washing machine. Chair, I gave him 5,000 rand from the amount of 25, and the balance of 20,000 rand I used for the renovations to my house.
Okay.
Then, Colonel Naidu, can you deal with the purchase of airline tickets?
Chair, if I may, before I go there, I must also state that it was not normal practice for crime intelligence to purchase vehicles from private individuals.
Yes. Okay.
Thank you, Colonel Naidu. Will you now deal with the purchasing of the airline tickets?
Yes, Chair. Chair, when General Mluli was appointed in 2009, almost immediately, Chair, he was flying to Cape Town almost every week. Initially, I used to take, on the instruction of General Lazarus, I used to take an advance on my name, go to the airport and pay for his flight, and subsequently hand the air ticket to General Mluli. Chair, this was putting quite some pressure on me because basically this was almost every week that General Mluli was either flying to Cape Town or he was flying somewhere, but most of the trips I remember were to Cape Town.
Was it like over weekends or during the weekdays or both?
Chair, most often it would be from a Friday to a Monday, and some instances Thursday to a Sunday or Monday. So you're incorrect in saying that it was mostly over weekends.
Okay.
Chair, I also recall booking flights for two individuals linked to General Mluli, Ms. T. Lines and EK Lines. Chair, at that stage, Ms. Lines was General Mluli's girlfriend and EK Lines was her sister. Chair also made bookings for his two children, whose names are known to me, but I won't mention them.
Yes. Yes, continue.
Chair, all of these bookings for flight tickets were paid out of the Secret Service account. Chair, like I mentioned, initially it was cash payments that I would take in advance and go and pay for these tickets. But like I said, the flights were almost every week.
Yes.
Eventually arrangements were made to book tickets through Westfield Travel, pardon me, Chair. I previously testified to Westfield Travel and their role in with regard to the flight tickets insofar as crime intelligence goes. The process was that I would get an instruction from
do you know, I'm sorry, do you know of any reason why when you were all operating from Gauteng, travel agent in Durban had to be used, Westfield travel agents?
Chair, this was a contact of FM08, Chair. FM08 was previously based in KZN. He was a constable there prior to being appointed during the 250 post, and he was transferred to head office. So this was FM's 08 contact. He made use of this particular travel agent while he was based in Durban, Chair. So when FM08 relocated to Gauteng, he was based at head office crime intelligence. We used this contact, and I know this person by the name of Mahesh was introduced or introduced to me by FM08. So in terms of General Mgluli's flights, Chair, whenever he wanted to fly an instruction of General Lazarus, I would either get the details from General Mgluli himself or via General Lazarus, and I would make the bookings telephonically with Mahesh, who is a travel agent at Westfield Travel. Chair, this was all done telephonically. There was no paperwork for any of these flights or approvals or anything to that effect.
But Westfield travel agents would have some records.
Chair, I believe they would.
I would imagine for their own purposes, they would have kept some records, I guess.
I believe they would have records, Chair.
Yes, but you don't know, do you, whether as part of his investigation, Colonel Rolofse has made contact with them and has their records or part of their records?
Chair, I previously testified to an incident where plans were made to destroy evidence regarding the air tickets. Colonel Rolofse would have documents relating to this particular service provider, Westfield Travel.
Colonel Naidu, just to clarify this, was that shortly before you went into witness protection when you had this meeting around the Braai area of General Lazarus's house?
Yes, Chair, this was on the 19th of October 2011. This was 2 days before I was admitted into the witness protection program.
And after you'd spoken to Colonel Rolofse?
That is correct.
The records that were mentioned in connection with destruction, were they records of the Westville Travel Agency?
Yes, Chair, but more especially it would be regarding crime intelligence.
Yes, that's what I'm talking about, insofar as they related to crime intelligence.
And that is correct, Chair.
But you don't know whether that plan was carried out?
No, Chair.
Okay, all right.
Thank you, Chair. Colonel Naidu, you say on page 58 of your statement that you know the number of renovations that were carried out using the SSA account on the instruction of General Lazarus. Could you deal with those?
Yes, Chair, that is correct. I know of the following renovations that were carried out with Secret Service account money. Chair, this was an instruction on the instruction of General Lazarus. Chair, and I referred to paragraph 247. Chair, General
Yes.
Mtwe, who I previously testified to receiving a vehicle from crime intelligence. Chair, she had a burglary at her house. It was in Essex World, Chair, in Bedford View. On the instruction of General Lazarus, Chair, electric fencing, security beams, and alarm system was installed. I personally know of this because I put in a claim on my name. Chair, again, 40,000 Rand.
Of approximately 40,000 rand.
That is correct, Chair. I can't say exactly, but if the documents are shown to me, I can confirm, but I know that I put in a claim for approximately 40,000 Rand.
And you said
What was the
claim in
obsession
your
with
name.
40,000 rand?
Chair, I really don't know. I think once the investigations are done, maybe we'll have more insight into these things.
Was there anything like, if it's above 40,000 rand, maybe there were certain procedural requirements for certain things to be done and you have to keep it not more than 40,000 rand or something like that?
I'll be speculating if I say anything, Chair. I'm not certain.
Okay, all right, yes, continue.
Chair, 248, I'm also aware of renovations carried out at the residence of General Mbluli in Don Park in Vosloorus. Chair, this also on the instruction of General Lazarus. He had a security overhaul by installing electric fencing, security beams, and an alarm system. New electronic gates, cameras, burglar bars were also purchased. Chair, this was paid out of the SSA. I say this because I personally put in an amount totaling, and it's not 40,000, Chair, it's 200,000.
Yes.
And again, was that claim put in your name?
That is correct, Chair.
So do you know whether in some cases, even with regard to General Mdluli, General Lazarus could just say something like, it looks like, you need some security upgrade in your house, let's do that. Or say to you, Colonel Naidu, don't you need renovations to be made in your house, or don't you need a new car? Doesn't your wife need a new car? And then things would then be bought with the secret service account money. I mean, one gets the impression that money was just being dished out.
Chair, that is exactly what happened, Chair.
Yes.
Chair also referred to Annexure 13, an application for these, as I've mentioned in paragraph 248, for these renovations or security upgrades to be carried out.
Yes.
Chair, it's very, very unclear. The copy is not very good, but this was a document that was authored by myself.
What page?
Chair, it's page 121.
121.
That is correct, Chair.
Okay, what document is that?
Chair, regarding what I've just testified to in paragraph 248, it was an application for these upgrades to be carried out.
At General Mdluli's Don Park residence.
That is correct, Chair.
Okay, so this is an application that you had to make to whom?
This was to General Lazarus for his signature. His signature is on the bottom as being approved. It was also signed by Colonel Rolabile, Chair.
Yes.
This document refers to the upgrades at General Mdluli's house. It was approved by General Lazarus.
Did the fact that this was in writing and that it was approved, did it make it legitimate, or that had nothing to do with its legitimacy? It was just because it had to be done. There had to be some paperwork.
Chair, I believe that there had to be some paperwork just to legitimize this particular transaction. But having said that, I don't know what the policy is regarding security upgrades.
Well, so you wouldn't know whether General Mdluli was entitled to any security upgrade in his residence at the expense of crime intelligence?
I can't be certain, Chair.
Yes, okay. Continue.
Yes, Colonel Naidu. Which other upgrades?
Well, I'm sorry, we are at 1:05, but I think we're close to finishing.
Yes.
So I think let's just go on and finish, and then
Yes.
we can take adjourn for the day.
Yes.
Yeah, okay. Is that fine with you, Colonel Naidu?
That is fine, Chair.
Okay.
Colonel Naidu, could you then deal with the renovations that were carried out to Minister Nati Mtetwa's property?
Yes, Chair, I was personally involved in this transaction. I was informed by General Lazarus that we needed to do some upgrades at the Minister's house. Chair, I'm not sure where this instruction came from, but with regards to myself, it came from General Lazarus to me. Chair, this was to put up a boundary wall. This was at the Minister's house.
I'm sorry, I think I thought you were going to 249. You've gone beyond that, huh?
We
Was
had
249 taken care of?
Yes, it was.
Okay.
It
Are you?
deals with that annexure that was so badly,
Oh, okay. Are you at 251 now?
yes.
Okay, all right. Yes, continue.
Chair, I was given instruction by General Lazarus. Chair, I just want to correct this, 251, and I'm going to read it. General Lazarus informed me that that he had received an instruction from General Mgluli, who had received an instruction from Minister Mtetwa. Chair, I'm not sure about that. I can't say that I received an instruction from General Lazarus and he received an instruction from General Mgluli. This part I'm not sure of.
He didn't say to you that General Mdluli had received an instruction from the minister?
No, Chair.
Okay, so this was an error on your part.
That is correct, Chair.
Okay.
Chair,
Yes. And the instruction from General Mdluli, according to
General
General Lazarus, was?
that arrangements be made for the construction of a boundary wall, Chair. This was on the or rather on the perimeter of the residence of Minister Nathi Mtetwa. Chair, this was in Kwamanambi in KwaZulu-Natal. Chair, I know where the premises is because I had previously gone there. We flew to KwaZulu-Natal, Chair, and I say I refer to General Mgluli and myself. He was having a meeting with Minister Mtetwa, and I drove him there to this particular premises. So
Yes.
I know where the premises is.
Yes, okay.
Chair, subsequently made on the instruction of General Lazarus, I traveled with FM09 to the minister's property to meet with another agent. Chair, this is FM46. This was the agent who was going to oversee this project at the minister's house.
And so
That
did you
is
fly?
FM46.
That is correct, Chair.
Okay, yes.
FM46, and I flew to Durban with FM09
Yes.
to meet with FM46.
Yes.
Chair, this was purely to familiarize FM46 as to where the property was and what needed to be done.
Yes.
Chair, I'm not sure on this occasion General Lazarus accompanied us or on the second occasion. But what I can say was when the project did start, I remember having a conversation with General Mgluli, and he said to me the minister wanted to know why we are taking so long with the project.
Yes.
Chair, what I understood to be is that the minister inquired from General Mgluli why we, as in crime intelligence, is taking so long with the project.
Yeah.
Chair, I informed General Lazarus about the conversation that I had with General Mgluli. We made arrangements to fly to KwaZulu-Natal, drove to Kwamanambi to meet with FM46. This was myself, General Lazarus, and FM09. Chair, Minister Mtetwa's his concerns, I would say, was indeed correct because there was hardly any work done. I think there was just a few trenches that were dug.
I'm sorry, I must have missed something. Concerns arising out of?
Chair, with regards to the progress of the project, Chair, it was taking too
You
long.
mean the concerns about the delay?
That is correct, Chair, because this trip came about. The conversation that I had with General Mgluli, the minister inquired from him why the project was taking so long. This trip that I undertook with General Lazarus and FM09 came about from the conversation that I had with General Mgluli regarding the delay in the project or the progress of the project. We flew to Durban, met with FM46, and as I said, Chair, indeed the progress was quite slow. It was very slow, in fact. There was just a few trenches done. In that conversation or in that meeting, General Lazarus put pressure on FM 46 to expedite the project. Chair, the arrangement for payment for this whole project at the Minister's property, I remember putting in 3 claims, Chair. It was over a period of a few months. I can't remember the exact figure, but it was just under 200,000 rand. If the claims are shown to me, Chair, I can confirm that it is my signature and it was for that particular project.
Okay.
So again, Colonel Naidu, the claims were put in under your name.
That is correct, Chair.
Those claims would relate to, that is, to get money to buy material and to pay for labor.
Chair, that money was paid for labor, building material, and other related expenses that were needed.
Traveling.
Not so much traveling, Chair, because this was an agent. He had a vehicle. He was making use of a SR vehicle at that stage, so there was no traveling cost. It was purely a building-related cost.
So the actual building of the wall was undertaken by an agent?
The agent oversaw this project, Chair, yes, that is correct.
Or he oversaw the project, but
That is-
didn't necessarily do the actual building of the wall?
No, Chair, there were
He
local...
got somebody else to do that?
That is correct, Chair. There were local contractors
Contractors.
hired to do this particular work.
Okay. Okay. What, did the wall that was built, did it go right around the house, or there was another wall and there was maybe one side or 2 sides that did not have a wall, or what was the position?
Chair, it was a perimeter, it should have been a perimeter wall. I'm not certain, Chair, because I can't comment because I didn't go back to Kwamanambi after this meeting that we had with the agent, so I can't say for certain.
But when you went there before the wall was built, was there a wall that was there already, either going right around the house, or was there no wall at all, or was there a wall that covered one side of the house and not other sides?
Chair, if I can remember correctly, when you enter the premises, there were 2 pillars on the entrance. And if I can recall correctly, there was fencing, Chair, wire fencing.
Wire fencing?
That is correct, Chair.
Okay, all right. Yes, continue.
Colonel Naidu, under the heading miscellaneous, do you have personal knowledge of what is stated in your statement under that heading?
Chair, I referred to paragraph 253. I remember having a conversation with FM 46. Chair, this was around the time that preparations were undertaken for Mr. Marimutu's birthday party in KZN. Chair, FM 46 complained to me that the demands from Mr. Marimutu were increasing and that the bill was escalating. This is the conversation that I had with FM 46, Chair.
Yes.
And the further things stated?
But this is the conversation I can recall, Chair, with FM 46.
I'm
Yes.
sorry, where are you now, Ms. Swenson?
On page 60, paragraph 253 onwards.
Okay.
The other events, do you have personal knowledge of them stated there?
Chair, I also had a conversation with General Lazarus, I can't remember the time period, where he informed me that General Becky Taylor allowed him to use money from the Secret Service account to pay for his attorney's fees. Chair, this was a time when General Lazarus was being investigated by the Hawks. At that stage, General Mbluli was suspended.
So just repeat that.
Chair, like I said, I remember having a conversation with General Lazarus, where he informed me General Becky Taylor allowed him to use money from the Secret Service account to pay for his attorney's fees. Chair, this was when the Hawks was investigating General Lazarus, and at that stage, General Becky Taylor was a national commissioner.
Yes. And General Lazarus said General Kele gave him permission to use the Secret Service account funds to pay for his, that is General Lazarus' attorney's fees.
That is correct, Chair.
Okay.
Thank you. Colonel Naidu, could you tell the Chair whether you submitted false claims for your own benefit during the time that you were employed at Crime Intelligence?
Yes, Chair, like I testified to earlier in my statement or my testimony, it was probably around 100,000 Rand, Chair. I can't be sure. It might be more than that. But like I said, I will only confirm when the claims are shown to me.
Yes.
Now, Colonel Naidu, after you were placed in witness protection, did you testify at disciplinary proceedings brought by the South African Police Services against General Lazarus in March 2013?
Yes, Chair. In 2013, on behalf of the police, I was a witness in the disciplinary proceedings of General Lazarus. Chair, of what I understand, he was subsequently dismissed from the police.
And could you tell the Chair what occurred at those proceedings?
Chair, during that proceedings, Chair, I was accused, or rather, let me put
Well,
it-
let's start with what were the charges that General Lazarus was facing. You don't have necessarily to, I don't expect you necessarily to be exact in terms of how they were termed, but in terms of substance, what, as far as you know, what charges was he facing?
Chair, it was a few incidents regarding his conduct while the CFO of the Secret Service account, Chair. I can't remember the exact charges, but one was for the safe house that he lived in while he was renovating his house.
Did some of the allegations relate to matters that you have covered in your evidence in this commission? Relating to
Yes,
him?
Chair. Yes, Chair. If I can remember correctly, it was.
Yes. Okay, so was it fraud-related, corruption-related allegations?
That is correct, Chair.
Yes. Okay, and you say he was found guilty and was dismissed?
That is correct, Chair.
Okay, and you were about to say something about yourself. You gave evidence in that disciplinary inquiry.
That is correct, Chair.
Okay, was your evidence were the allegations based to a very large extent on your evidence, or is that something you are unable to say?
It's a few matters that I have covered already in my testimony, Chair.
Yes, yes. So, but what I mean is, your evidence was, as far as you know, quite important for that disciplinary inquiry. Or is that something you don't
I would
know?
believe, Chair. I'm not sure what was the actual outcome or on what grounds General Lazarus was dismissed. I don't have that detail.
Or you don't know what he was dismissed for?
No, Chair.
You don't know the outcome of that disciplinary process?
I know that he was dismissed from the police, Chair, but I don't know the circumstances on which charges he was found guilty.
Yes, but do you know whether his dismissal emanated from the disciplinary inquiry in which you testified?
Yes, Chair.
Yeah, what you don't know is which of the charges he may have been found guilty of.
That is correct, Chair.
Yes, but the dismissal followed the disciplinary hearing that in which you testified.
That is correct, Chair.
Okay, all right. Ms. Wenzel.
What transpired at that disciplinary inquiry, Colonel Naidu?
Chair,
You might wish to formulate your question much more narrowly, because I think I know what you are looking for. But if you put it like that, you are inviting him to tell us everything about that inquiry.
Yes.
Yeah.
Thank you, Chair. Colonel Naidu, did something
Well, let me
occur-
put it for you. Did you ever get a chance, subsequent to that disciplinary inquiry, to know the findings that were made by the chairperson of that inquiry? Either in writing, did you ever get to know his ruling or his decision and the reasons that he gave for his decision?
no, I was not privy to that, Chair. I haven't seen any document.
As you speak today, have you been given that document in preparation for this, in preparation for your evidence in this commission?
No, Chair.
Okay, well, Ms. Wenzel might have something to say about that.
Yes.
How come?
Chair, it wasn't dealt with by him. We've, subsequent to preparing the statement, I believe that because Advocate Pretorius was involved in this disciplinary inquiry, that now that document has become available to the Commission and it can be dealt with him, but it hasn't been dealt with.
Yes,
him.
but how can it be dealt with him now without him having had a chance to read the ruling and understand exactly what it says and how it affects him? It could have been given to him.
Yes, it could have.
Even last week.
Yes,
As
it
I
could have.
understand it, you or Mr. Peterson, or you were aware of it at the time of, even before Mr. Colonel Rolofse gave evidence.
Yes.
So it could have been given to him then to read and understand, and he could have been told that he would be asked about it.
Yes, Chair, to clarify, what wasn't dealt with was going through the entire transcript, but what was certainly dealt with him were the findings that Mr. Pretorius made about him and his credibility.
That was brought to his attention.
That was brought to his attention.
Okay.
And it was brought to his attention in the context of the in-camera application. And Chair, you will remember that in that context, Minister Chele's counsel had said that this shouldn't be heard in camera, and that he is not a credible witness, Colonel Naidu, and he was shown what Mr. Pretorius had said, and that
But was he not given the whole ruling to read?
He was shown the ruling, and that we
He was
had.
shown but not
Yes.
given to take home and read.
No, not to take home and read. but
Why
he-
not?
Chair, because we dealt with it during the course of the consultation.
Yes, but
and
I'm
we
saying
dealt with-
it's only fair that he should have a copy, especially if certain findings were made that are adverse to him, and because that may come up. It's only fair that he should have the benefit of reading the whole ruling.
Yes, Chair, I understand that and I appreciate that. And I wasn't going to deal at this stage with that in any more detail than to give him an opportunity which we have discussed and which he very much wants to deal with. That finding that was made against him, and he has comments that he would like to make on that.
Yeah, I'm concerned about giving him an opportunity to comment on that in circumstances where he has not had the benefit of reading the whole ruling. That's my concern. And I don't know if he appreciates the disadvantage that he may be putting himself under if he wants to comment on part of the ruling without reading the whole ruling and the reasons.
Yes, Chair. Chair, I understand that difficulty. I did contemplate that after Colonel Naidu's evidence, there would be a number of applications to cross-examine Colonel Naidu. We've already had communication at the Commission with a number of people stating that they would like to cross-examine him. And I viewed that this is an issue that would have been dealt with properly during that cross-examination if it were to be granted. What I wanted to put to Colonel Naidu at this point is that he is aware that because he admitted to wrongdoing in the Commission himself, Mr. Pretorius found that this was a man who on his own version...
Yeah, but that's my point. Why must you even deal with that before you give him a chance to read the whole judgment? It's only fair.
Yes, Chair.
Yes, why don't you say you give him the judgment, the ruling, he reads the whole ruling, then you say, after that, I want to put certain questions to you. Then he can comment with a full understanding of the context.
Chair, I might try and explain to you what happened, is I met with Colonel Naidu and we spent a long time together and we went through this whole aspect. We went through the whole ruling together. I didn't give it to him and say, go away with it. And
so he has read the whole judgment, the whole ruling?
I understand that we went through that
whole process,
but
Colonel Naidu,
deal with it.
Colonel Naidu?
Yes, Chair.
You understand the exchange that I've been having with Ms. Wenzel?
Chair, I can't remember reading the judgment, Chair.
Yes, but I'm asking you whether you have been following the exchange between myself and Ms. Wenzel.
Yes, Chair.
Are you happy to be asked questions on aspects, on whatever aspect that Ms. Wenzel wants to ask you to comment on without having had the benefit of reading the whole ruling first?
Chair, this is not regarding the actual transcript as per se in totality. I would just like to speak on one aspect or incident that occurred during this proceedings, Chair. So it's not going to put me at a disadvantage.
Yeah, but why must you speak about this piecemeal? Are you not going to want to deal later with other aspects of the ruling?
Chair, if perhaps what we could do is if we could adjourn now, and I can give Colonel Naidu the whole ruling. He can have an opportunity to go through it.
Yeah, no. I'm not happy about this.
Yes.
Give Colonel Naidu the whole ruling.
Yes.
He must have a chance to read it properly. He might not appreciate certain things. He might be in a rush to comment on things without reading it.
Yes.
He must be given the opportunity to read the whole ruling properly, and then at some stage or another he can then deal with any aspect of the ruling.
Yes.
And not piecemeal. So and as I say, he should have been given a copy, his own copy, to read at his own time.
Yes, I appreciate
long
that,
before
Chair.
today.
Yes, Chair,
So,
I appreciate
so
that.
I don't want to allow any question relating to the ruling
Yes.
that may relate to any adverse finding made against him until he has read the whole ruling.
Yes, Chair.
And in terms of when he may be asked, there is, I think, no reason why we should then now adjourn for a short time for him to read that and we come back. I think he can be given a full copy. If you have got no other questions, if you have got other questions outside of the ruling, you can ask him and we finish for the day. Otherwise, if and when anybody is granted leave to cross-examine him, then he can come back, and before he is cross-examined, he can be asked questions on whatever you wanted to ask him. He can deal with any questions having fully read the ruling. I think that's how we should deal with it.
Yes, Chair.
Yeah, you understand, Colonel Naidu?
Yes.
Yes.
Pardon me, Chair. Yes, I understand, Chair.
Yes. So before anybody will be able to say, but such and such an adverse finding was made against you, he must have had a chance to read the whole ruling and be ready to deal with any question.
Yes, Chair.
Okay.
Chair, I don't intend to ask questions directly about the ruling. Colonel Naidu, I want to deal with you with what it has been like for you to be in witness protection. But before we do that, I think that there is an issue that the Chair would like to understand, and indeed I think the public would very much like to understand. And that is why, when after you had first been questioned by Colonel Rulofsa on the 18th, I think it was, of October.
That is correct.
Why did you say that on the 19th, despite your own involvement in this wrongdoing, did you decide to tell him everything that you knew, including about your own wrongdoing?
Chair, this might take a few moments, if I may.
Yeah,
Not
that's
just
fine.
a straightforward answer. Chair, when I was appointed at Crime Intelligence initially in 2002, over the next few years, Chair, I became quite close to General Lazarus. And over the next further few years, I became his close confidant, well established within his inner circle, and to an extent involved in the web of corruption that he had already established. Chair, I spoke of the relationship with Mr. Marimutu and General Lazarus, how he came into the picture. Chair, when Mr. Marimutu, or rather when General Lazarus established a relationship with Mr. Marimutu, the abuse and the extravagance regarding the Secret Service account just went to another level. Chair, all of these things started to affect me personally, knowing what was going on. I remember 2 months before being placed in witness protection, on 2 occasions I came home and my wife noticed that I was not myself, and she asked me what was going on. Chair, without giving any detail, I said there's stuff that's going on at work which is not right, and I don't know what to do.
I'm sorry, just repeat that sentence.
Chair, I explained to my wife, picked up that I was not myself.
Yes.
And we had a discussion, Chair, without giving any detail to my wife as to what is going on at work.
Yes.
I told her that is things that is going on that is not right, and I don't know what to do about it.
Yes.
Chair, at that stage, or if I remember correctly, my wife told me that I need to speak out or I need to leave that unit and get a transfer. Chair, like I said, I was well established within General Lazarus's inner circle. Taking a transfer would not be an option for me at that stage. It would arouse suspicion as to why I'm transferring out of the unit. So at that stage, the transfer was not an option for me, Chair. And then this came around where I was interviewed by the Hawks on the 18th. Chair, like I testified to earlier, whatever questions were put to me on the 18th, I answered all questions honestly, but I was hesitant simply because I could not trust them, because as I've testified to, I've implicated numerous people, serious corruptions or allegations of corruption, so I didn't know if I could trust them. Chair, on the 18th, after being interviewed by the Hawks, more especially Colonel Rulofse and Colonel Viljoen, I had another discussion with my wife and explained to her the events of the day. And Chair, it was actually my wife who convinced me. It was my wife who convinced me to come clean, Chair. And on the 19th, of October, on my own accord, I disclosed all the allegations of criminality taking place within crime intelligence, including myself. Chair, there was a version put forward that I only did this because I wanted a secure deal for myself to avoid prosecution. Chair, this is totally untrue. On the 19th, I went there by myself. I didn't have any legal representative, made admissions incriminating myself with the prospect of being arrested myself.
Yes.
So this is totally untrue, Chair. In fact, after giving all of this information to Colonel Rulofse on the 19th, he was very frank and he was very honest with me. He said, you know, I can't say that there's nothing going to happen to you, there's no deal for you. Chair, however, he said he will speak to the prosecutor and see what he can do. Chair, on the 25th of October 2011, this was my first, if I can call it my blanket affidavit, which I deposed to Colonel Viljoen.
Yes.
In that statement or affidavit, I did say that I would like to be treated as a Section 204 witness.
Yes.
Chair, that process still has to unfold in the courts, and a decision has to be made. So the notion or suggestion that I only came forward with all of this to get a deal for myself to avoid prosecution is totally untrue, Chair.
So the position is that you appreciate that you have no immunity from prosecution as things stand, and that you may well be charged, but you may well not be charged. You are ready to face any consequences of your own actions.
That is correct, Chair.
Yeah, okay. Yes.
Colonel Naidu, is it correct, though, when you made your statement on the 25th of October, you did say you wanted to be treated as a Section 204 witness?
That is correct.
And in the subsequent affidavits that you have deposed to as requested by the Hawks, are those affidavits given by you on the basis that you would be treated as a 204 witness?
That is correct, Chair.
Is what
Does that mean that the Hawks have made the decision that from their part they will treat you as such a witness?
That is what I'm given to understand, Chair.
Yes, okay. But before that decision was taken, you had no guarantee for anything?
That is correct, Chair.
Okay.
So, Colonel Naidu, if I understand you correctly, what you are emphasizing is that when you essentially came clean on the 19th of October, at that stage, there was no decision offered to you or taken in terms of which you would receive immunity from prosecution yourself.
That is correct.
And you were making the point earlier that you didn't even go and get your own lawyer to assist you and guide you, and so that you could have some legal protection.
Chair,
You went to meet with the Hawks on your own without a lawyer.
that is correct, Chair. Over the 2 days of the 18th and the 19th, Chair, there was no subpoena for me to present myself to the Hawks. I went there willingly. It was a request for me to be interviewed.
Yes.
So there was no obligation on myself to present myself.
Yes.
I went there willingly, Chair.
Yes.
And on the 19th, as I explained, having made the decision and settled within myself already the previous night that I was going to disclose all information that I was privy or had personal knowledge of regarding criminality within crime intelligence, I had already made that decision the previous night and still presented myself on the 19th without any legal representative, knowing well that I could have well be arrested myself. That is my
Yes.
position, Chair.
Yes.
Thank you. Colonel Naidu, could you please tell the Chair what it has been like for you to be in witness protection?
Chair, before I go there, if I can just say this as well.
Yes.
My testimony has been quite extensive. I've touched on numerous incidents.
Yes.
I've implicated numerous people. Chair, insofar as where I was personally involved and had personal knowledge, Chair, I'm prepared to avail myself for a polygraph test and for the results of that test be placed on record before this commission.
Yes. Yes.
Chair, regarding witness protection, I can't go into much detail, but Chair, it's been difficult. It's been extremely difficult.
Both to you and your family.
Chair, next month will be 8 years
Yes.
that I will be in witness protection.
Yes.
It's been extremely difficult, Chair, especially the first few years.
Yes.
My children basically grew up.
Yes.
They've spent their prime years in witness protection. Our situation is very fluid, Chair. We live our lives on a month-to-month basis. We cannot make plans further than a month. So I'm hoping, Chair, that me coming and testifying before this commission, it will give some urgency to the processes that are outstanding, be it the declassification of documents or other information that has not been forthcoming.
Yes.
So I'm hoping that something positive comes out of me testifying at this commission.
Yes. Yes.
Chair, lastly, if I may, during my
Yes.
time at Crime Intelligence, I made decisions that I deeply regret, Chair,
Yes.
and I am truly sorry.
Yes.
I'm sorry for my actions,
Yes.
and I humbly apologize, Chair.
Yes.
Chair, I also want to thank you for allowing me to come and share what I know, extend my appreciation to you and the Commission, Chair.
Yes.
I thank you.
Yes.
Thank you, Chair. I
Thank you.
have no further.
You have no further questions.
No.
Thank you very much, Colonel Naidu. I have no idea what it must be like to be in witness protection, in a witness protection program. I have no idea what it must be like to have your whole family in a witness protection program for 1 year. I have no idea how it must be like to have your whole family, your wife and your children, in a witness protection program for 7 or 8 years. I understand that when you are in a witness protection program, your freedom of movement is very limited, and you live a life that is very unlike the life you would have lived before going into such a program. So it must really be quite difficult. I must thank you, Colonel Naidu, for coming forward to give evidence to the Commission. Persons who are implicated by you in your evidence will have opportunities to apply for leave to cross-examine you, and will have opportunities to apply to give evidence themselves. I don't know what conclusions I will reach later in the work of the Commission when I look at your evidence as well as the evidence of those who are implicated in your evidence. But I do think that it was important that if you believed that you had been party to various acts of criminality and corruption involving taxpayers' money, that you spoke to the Hawks and placed before them what you believed were the facts, and in that way you may have helped in us understanding what may have been going on in crime intelligence. And it may be that all of this will also help in measures being taken to avoid criminality happening within crime intelligence, particularly with regard to the Secret Service account. And society does need people who will give cooperation to law enforcement agencies when there are suspicions of criminality, particularly with corruption, which has reached very unacceptable levels in our country. And without some of the people in society making decisions to tell the authorities about wrongs that may be happening, not much can be done. So I just want you to know that I think I do have an appreciation that what you and your family must have gone through over the past 7, 8 years could not have been easy and must have been difficult. And I want you to know, and your family to know, that I really appreciate, and the Commission appreciates, the sacrifices that you may have done in order to try and share with the nation what you believe are the facts of what happened. As I say, other people will come forward and will put what they believe are the facts, and in due course I will make findings, but I appreciate very much that you made yourself available, and we probably will ask you to come back because you also might need to deal with certain aspects relating to the ruling. But there is some further investigation that needs to be conducted in regard to some of the aspects of your affidavit, those where you also felt that more investigation needed to be done before you could deal with them, because you were not sure of the facts in regard to those. So, but thank you very much for coming to share with the Commission and with the nation what you know in terms of what has been happening or what happened in crime intelligence. I have already asked the head of the legal team of the Commission to be in touch with relevant authorities with a view to getting finality on the issue of the declassification of documents that may be important for some of the allegations that you have dealt with and that Colonel Rolofs had dealt with as well. But thank you very much, Colonel Naidu. We appreciate your having come forward.
Thank you, Chair.
Yes. We are therefore going to adjourn the proceedings for the day, and the legal team will be in touch with you, Colonel Naidu, in regard to the other matters, and also in due course when you may have to come back. Tomorrow, the Commission is scheduled to hear the remaining evidence of Mr. Tabete, the former head of the Department of Agriculture in the Free State. That is scheduled for tomorrow and Friday because he didn't finish his evidence. But we will not be able to start in the morning because tomorrow the judiciary will be accounting to the nation with regard to its activities, and that will be happening at the Constitutional Court. The Chief Justice will be doing that, and I need to be there for the morning. So we will start here tomorrow at 2 to then hear the further evidence of Mr. Tabete. I thought I must mention that so that those who might need to be here, they know that we'll only start at 2. We'll then adjourn for today. We adjourn.
All rise.
Yes. Very nervous.